May it please, Your Lordship.
It's a special bench, so as soon as this gets over, then we will resume our regular bench. This is only for the curative petition. After that, we'll come back and take up the regular bench work. Yeah.
It's in the curative petition, my Lord, out of the available grounds, my Lord, obviously I'm not raising a ground of any bias or anything, my Lord, that Your Lordships can record. My Lord, the contention is that Union of India was not joined as a party before the High Court, and that violates the principles of natural justice, my Lord.
You were before the Supreme Court.
Lord, it was my SLP and I was heard, my Lord, by this court, but respectful submission is that that may perhaps not cure the defect of not hearing me by the High Court.
That's the only ground that you are.
My Lord, another ground, my Lord, which I am respectfully urging, my Lord, for Your Lordship's consideration. Lord, it was our contention that the contract is not yet concluded.
That will be going to the merits of the matter, sir.
Lord, contention was that they should have filed a suit for specific performance or for damages, my Lord. REIT was definitely not maintainable.
Will it fall in those three categories of Pura?
Lord, third category is a little broad-based category, my Lord, if Your Lordship. It's entirely Your Lordship's discretionary jurisdiction, my Lord. Curative is never, my Lord, an intra-court appeal, my Lord. I am conceding to that legal proposition. But this is how, my Lord, we have couched page 54, and then, my Lord, I end, my Lord. Page 54, para 49.
Just go to page 54.
Para 49, the order of this Honorable Court. In the facts of the present case and the findings so recorded herein above, it is clear that the authorities have acted arbitrarily in violation of Article 14. In such a situation, the public law remedy has rightly been availed, invoking the jurisdiction of the High Court under 226. The findings recorded by the High Court to entertain the petition in 95 are just and proper, and we are all in full agreement to those findings. In the facts of the present case, the argument advanced by the appellants to compel GAL to take the remedy of specific performance under the provisions of the Specific Relief Act is hereby repelled. My Lord, Specific Relief Act provision also can be invoked against an arbitrary order. My Lord. That's the
Non-exercise of jurisdiction under Article 226. It's a self-imposed remedy.
my Lord.
APL Corporation.
Lord, these are the only two, my Lord.
Actually, there are two things. As first aspect, you pointed out that the Union of India was not a party, but you were heard away.
It was my SLP, I must tell your Lordship, my Lord.
But the other is the question of power judicial review. To what extent the power judicial review can be exercised in such cases? Because Union of India was kept out of it. Ultimately, you're the controlling authority. Now, we don't go into commercial wisdom, etc. That means that we accept the principle of separation of powers. Secondly, is whether in a writ court we should be then directing execution of a contract where the Union of India feels commercially not a wise decision and for good reason.
Lord, commercially, the Airport Authority of India would have an interest. And I must, my Lord, fairly, my Lord, assist your Lordships. AAI was a party because this is always, my Lord, a JV where AAI also becomes a profit sharer.
What your proposition was that the profit sharing sector is not commercial.
No, that was not, my Lord, the case of AAI, I must.
For the case of AI, that it is not maybe commercially viable, looking to the
Second, enhancement, which was the enhancement part, but you had reservations on that part. You had reservations on that. And you must have undertaken that exercise. So do you have the inner notes of your?
No, do we have? I don't think we have, Lord, but we can, my Lord, take instructions on that.
You know, on the first point, Mr. Solicitor, that the Union of India was not joined as a party, once the Union of India comes in appeal before the Supreme Court, obviously the appellate bench has two options. It can either remit the matter back to the High Court, say that impede the Union of India and rehear the matter, or in a given case, it can hear the objections of the Union of India in the Supreme Court itself. So, though you may have a technical point that, look, the breach of natural justice at the trial stage cannot be cured by an appellate remedy, natural justice and appeal. But of course, the court has broad powers to either do one of the two. That perhaps, especially because we are exercising curative jurisdiction, that first point may not carry that much of weight for the reason that you have been fully heard in the appeal. So therefore, that's the first. There is now on the second, as Justice Sanjeev Khanna focused, namely that
Can you produce before us your files where you took that decision?
I can.
Let's have a look at that.
can produce the file before us
Please,
on
sir.
Friday morning.
Please.
Can I assist you for 2 minutes, please?
Doctor.
I know Your Lordship putting on Friday, and I'm not going to take more than a minute today, more than 2 minutes. Your Lordship should know this. I've got a note. I'm just oralizing. Give me 2 minutes by the clock. My
You have
learned
our
friend-
notes. And the court wants our notes.
Can I make a submission, sir?
No, no, if you have, then please show it.
And I don't need permission from anywhere except this side.
Is a very healthy
This,
thing.
can I take
Yes.
a minute? Your Lordship should know this. That PMIC, the body which did the whole thing, has the government of India. They are fully aware from inception of day one
What
about
does
this.
PMIC stand
Well,
for?
that is the Project Management Committee.
It's
The
the
principle,
we'll have the file, we'll
Very
just
well.
have a look at it.
very well. And the natural justice,
But
fellows,
we're cutting short the arguments.
very well. Natural justice, 3 days the matter is heard. His non-joint day is considered. He's joined and heard fully in the Supreme Court. Anyway, I'll deal with it.
Why you arguing something which
Very
you're
well,
not asking
very
you to
well,
argue?
very well.
The Mr. Tushar Mehta, the Solicitor General, states that in the pursuant to the request of the bench, the files pertaining to the decision which was impugned before the High Court shall be produced from the record. This one, we'll take it up on Friday.
Very deeply obliged.
Obliged to.
I'm craving my lord's indulgence.
Took a few moments because we had an opportunity to only
Lordship.
converse right now because my brothers were traveling over the weekend. So
I'm taking a lot of.
we are
To
obliged, my lord.
mention, Malas, the matter, the so-called Baiju's matter. Your lordship's order, Malas, froze that 150 crores. That is no problem. Your lordship has frozen it. Your lordship's added a sentence. There'll be a stay of the order. Now, Malas, the stay of the order means the CRP will revive. Now, under COC, normally COC would be a constituted end.
we are taking up the matter. We are
On the
No,
23rd.
no, Malas, your lordship is taking
No, it's
23rd.
not coming up.
What has
today,
happened
but
is
some
that your
interim
lordship's,
arrangement. I
your
support,
lordship's
Dr.
order.
Singhvi.
So one
take it up. So Dewan will take up the matter. There's no difficulty.
They should not, COC should not be,
Obviously not.
no,
They
not,
will take up some
COC,
independent-
COC should not be constituted in that time because then I have to file a 12A.
My lord, COC.
I am not objecting, Malaj, I am saying,
Hearing the parties, it's coming up.
Well, I am-
Made a tentative
I am-
observation, it's
I am only
unconscionable.
say-
You have stated.
Lord, only a minute, my lord.
How many people
Appointment
speak?
of a COC
All that we
constitution.
can do is. There
RP should not constitute the COC before Friday, that's all I am saying.
Lord, constituting
may be
COC.
some difficulty about this combination of three sitting on Friday. We can take it either on Thursday or Monday, whatever is
But
convenient.
can it be tomorrow, my lord, subject to your lordship's
Tomorrow or-
availability and.
Tomorrow we have the constitution
Or
bench.
then Thursday,
Tomorrow is the constitution bench.
Lord, Thursday, my lord.
Thursday.
Thursday, my lord.
We can take it up on.
Because
Surely between now and day after, they will not constitute.
Lord, it is,
Fair enough. You
the matter, my lord, without hearing will be allowed if COC is
So
constituted.
Thursday we'll take it.
Only one sentence, well, it will be infructuous if the COC is made in these 48 hours. They should not make a 48 hours.
Yes.
Very well, Manas. We made our concerns clear to your lordships. If they go and create a COC in these 2 days.
The others, can you just circulate emails? In the afternoon, I'll deal with your emails and ensure that all matters are listed. Just circulate an email.
Which is connected to Sumoto writ petition 2 of 2024. Like that writ petition was filed by Association of Healthcare Private Limited, Tamil Nadu chapter in 2019. Notice was
Order for listing the matter. Just talk to the registrar in 10 minutes. Once he is free from here, there would be already an order for listing.
So this is now.
Lords, if your lordships can consider indicating, my lord, the concerns which your lordships would like us to assist.
Solicitor, Mr. Sybil is appearing for the state of West.
Your Lordship, with Mr. Sabin, in this matter, Your Lordship, I'm also assisting Your
I'm
Lordship.
appearing for the Delhi Medical Association, Lord. We have filed an application.
State of West Bengal is represented by Mr. Sybil.
Yes, Lord.
Lord, I appear for
Is-
the Indian,
The Bengal Doctors, the Association of Bengal.
Lord, I am appearing for the original writ petitioner on
Your Lordship, I'm,
order the CBI was done.
my Lord, I'm appearing on behalf of the petitioner.
Number of interveners.
yes,
Please,
Lord.
sir.
Have
Appearing on
calling
behalf of
out-
the petitioners.
calling out who they are appearing for. We'd only request the interveners to give a slip of paper to the court master indicating who you are appearing for. We'll take that.
We'll
on.
give it, my lord, I,
Otherwise, we'll spend the next 10 minutes and only,
I am appearing for the Indian Medical Association, will give our slip, my lord.
And my lord, I am for the writ petitioner at whose behest the investigation was transferred to CBI.
Right. But the reason why, I must make it clear, the reason why we decided to take suo motu cognizance, we are conscious of the fact that the High Court was entertaining a petition which was filed by the petitioners who are here before us, is because this is really now not just a matter relating to a particular murder which takes place in a hospital in Kolkata, which is horrific in the nature of the crime, but it raises systemic issues in regard to the safety of doctors.
My lord, two more incidents, one in Bombay and one in Ahmedabad after Calcutta.
Let the Chief Justice, please.
Because this deals with the systemic issue of safety of doctors across India.
Yes.
There are a couple of things, Ms. Sybil, before we deal with the broader aspects of safety and what we propose to do, we'll tell you in
I have something to assist on that, my lord, neutrally.
briefly on both aspects. First, on matters of safety, we are deeply concerned about the fact that there is a virtual absence of safe conditions of work for young doctors across the country, particularly in public hospitals. As we know, these are all young interns, they are residents, senior residents, doctors, and most importantly, women doctors.
Yes.
who are subject to of graver dangers and vulnerable
Yeah, vulnerable.
by virtue of the nature of their
Absolutely.
because of gender.
Working hours.
Just and working hours. Most of the young doctors have to put in somewhere
36 hours,
36 hours.
Malad, stretch.
We find that there are no duty rooms available, no separate restrooms or duty rooms available for men and women doctors, for the other nursing staff, for the paramedical staff who are also on duty. And therefore, we must evolve a national consensus to ensure that there must be a standard national protocol to ensure that safe conditions of work are provided. This is not a matter of providing protection either to women or protection to doctors in general. It's a matter of creating safe conditions of work. So that they, ultimately, what is equality under the Constitution all about? If women cannot go to a place of work and be safe, then we are denying them the basic conditions of equality. And therefore, we are entertaining this, and I'll very shortly share the way we want to proceed with this to ensure that ultimately, it's not that every time that there is a rape or murder that the conscience of the nation is awakened. We have to do something right here and now to ensure that these conditions of safety are maintained in terms of protocols which will not just be on paper, but protocols which will be enforced across India. Now, insofar as what happened in Kolkata is concerned, a couple of things from what we have. Of course, first, let me begin by saying that we are deeply concerned of the fact that the name of the deceased who was assaulted and murdered, the name has been published all over the media. Photographs have been published all over the media. Video clips, obviously, either before or after the postmortem, have been published.
Right.
Showing her body, after she was subjected to it. Extremely concerning. We are the first to recognize the right to free speech, but there are well-settled parameters.
It is extremely painful. I agree entirely with you.
Which have been laid down in now the new criminal procedure code by judgments of our court in Nipun Saxena, that you will not publish the names of the survivors of sexual assault. In this case, the person
It's a criminal offense.
We have filed 50 FIRs on that count. 50 FIRs.
And it was circulated, nobody should publish.
May I just inform your lordships, before the police reached, photos were taken and these were circulated. We didn't allow anything to happen. We cordoned off the area.
This is the way we provide dignity and respect the privacy of an individual who has lost her life as a young doctor.
Yes.
But apart from that, Ms. Isabel, I'm happy that you are here for the state of West Bengal. Couple of quite a few aspects of the way the matter proceeded. It appears that the crime was detected in the early hours of the morning.
Yes.
After the crime was detected in the early hours of the morning, the principal of the hospital tries to pass this off as a suicide.
Not true.
Her parents are not allowed to see the body. The parents are not allowed to see the body for almost.
No, Malad, I'm sorry. Anyway, Malad, this is the impression.
Our investigation
We'll have to place the facts before your lordships. We have investigated that. This is not correct.
Until late night, we find that no FIR was registered.
That's also not correct. Not correct.
What time was the FIR registered?
Malad, in fact, we did what is called what we call a UD case, Malad. Unnatural death case registered.
Yes, unnatural death case
Registered.
But
immediately.
that's right.
That's an FIR, Malad. That's an FIR.
Not the body is discovered.
The UD case.
The FIR registered formally in the police.
Malad's inquest was done and then FIR registered immediately and the investigation started.
What time
It should have been done.
the FIR registered?
12, Malad. 12:30.
Does the FIR say that this is a case of a murder?
No.
Yes.
No, it.
No, my lord.
Unnatural death. It was.
We have something.
Unnatural death.
One second.
Inquest shows it's a case of murder,
One
Malad.
second.
Inquest shows it's a case of murder.
Inquest is done. The postmortem the autopsy is conducted.
Yes.
Now, until the night, no FIR indicating that this is a clear case of a murder has been made out.
It has, Malad. I'm sorry. I'll place those facts before your lordship. It has been, Malad.
Lord, may I suggest?
From
Lord, may I
unnatural death,
suggest-
he registered the case
Lord,
for murder.
eh,
We caught the victim. He is a civic worker, Malad. It's an individual act. I show all that to your lordship.
And that's the first aspect.
Yes.
What was the principal doing? Why did he not, one, why was this kind of inaction on the part, first, an attempt to pass this off as a suicide instead of a murder?
I'm sorry, Malad. That's not correct.
Not recording, not registering an FIR till late in the evening. Third, the body itself is handed over to the parents sometime in the evening for cremation. Fourth, and that's a matter of very serious concern. On the next day, the doctors, because they were all doctors working with her, the doctors are on protest. A group of persons, a mob assembles at the hospital. The hospital is invaded and the critical facilities are damaged in the morning or whenever the mob enters. What was the police doing?
Yes.
Not
Malad, we have videos for all. Malad, let me first of all state.
Surely, Mr. Sibal,
What-
the police,
Lord,
Malad,
a very serious offense has taken place. The crime scene is within the precincts of the hospital. Now, that is the first thing that the police have to do, namely to protect the crime scene. What are they doing?
Malad,
We allow vandals to enter the hospital.
It's impossible that
That's,
7,000 people
first
can
of all,
gather without
of all-
the consent.
Please, one second.
allow me.
Lord,
This is-
7,000 people
One
can
second.
never gather without knowledge or consent of the
This
police.
is not an adversarial litigation.
It's not. Therefore, let us not be in denial mode. One girl has lost life
One second.
It's-
by not only, a sexual pervert, he's an animal.
Principal, after the principal resigns from this medical college,
He sent to another
he's,
hospital.
he's appointed as a principal of another college?
He doesn't resign. But anyway, be that, Malad, let me
His
first.
conduct, at the least, his conduct is under scrutiny and he's appointed as a principal somewhere else?
Malad,
This is all, we have a note on all this
Malad,
misinformation.
it's not but each other, there is a high court
What
order.
is the reality? Just show it to you.
Let them file the report, not.
But just show it to you.
Tomorrow.
My lord.
Couple of things which we would
It
like
would
to
be
do.
there.
Well, let's make it very clear.
Yeah.
We would want the investigation has been handed over to the
CBI.
Bureau of Investigation.
Yes, done, yes,
We want CBI to file a status report before this court on Thursday.
correct.
We will take up the case on Thursday. We want CBI to apprise us on the status of the investigation.
Correct.
The investigation obviously must be at a very sensitive stage so that it's something which will be submitted to the court.
For court's
For the principal,
consumption, not
something that
the
is the case
making it
diary.
public.
It's
Yes.
really an investigation update
Yes,
status
yes.
report which will be given to us on Thursday. We will consider the status report on Thursday morning and see
Fair
where
enough.
the investigation is proceeding. Today, what we intend to do is that today we intend to pass an order. What we have done is, and three of us, that's why we were in conversation with each other. We have discussed the pros and cons. We are setting up under the authority of this court a national task force. The national task force will consist of a diverse segment of doctors from different parts of the country. We want them to make us recommendations in regard to the modalities to be followed across India. We're not only talking of the Ajikar Medical College and Hospital, but modalities to be followed all over the country for ensuring safety at the workplace first and foremost, for which our young doctors, the middle-level doctors, the senior doctors are all today on protest and on strike. At the same time, we would, now that we are taking charge of these proceedings, we are appointing a national task force. It's our earnest request to doctors all over the country who have struck work. There are institutions where I know appointments are taken 2 years in advance. For instance, the All India Institute of Medical Sciences, appointments are taken 2 years in advance. If patients lose their slot, they go back by another 2 years. So we would really earnestly appeal to all the doctors that we are here to ensure that their safety and protection is a matter of the highest national concern. And therefore, this is something which we would earnestly appeal to all the young doctors that this is something, please trust us. That's why we have not left it to just the High Court. The High Court, of course, consists of very seasoned judges. The Chief Justice was monitoring the investigation by the CBI, but we felt that this is now not a matter of a particular offense, however serious and horrendous the offense is, but something which affects the institution of healthcare pan-India. Therefore, the need for the Supreme
Mullahs,
Court.
we welcome this. I think this must be done, Mullahs. All of us must be very positive.
Lordships
But
may
Mullahs,
give-
I have only one request. Mullahs, I have only one request. Yeah, sorry.
My lord, I need, my lord, 5 minutes on this, my lord.
That's what I said. Yes,
Who is the first informant? We were talking about the first information.
yes.
Who is that first informant? Can you name us, please?
Name him.
Who is the first informant
we
who
just-
lodged the FIR?
The one, I just find out, Mullahs.
And we would also like to know the time of the registration of the
The
FIR.
father of the victim.
Wait a minute, please don't
Wait, please, don't-
interfere.
yeah.
Don't interfere,
The
please.
first UD case was done by the police on its own.
So that is not an FIR. What is section 174 of the old CRPC today? Can anyone assist us, please?
Yes, what's?
So that's just a report.
Yes, to start the investigation.
Then who lodged the FIR?
183.
First, the father of the deceased.
Yes.
Then
And
the
then the
vice
vice
principal of the hospital. First, the father of the deceased and vice principal of the hospital.
No, there cannot be two FIRs.
No, but both complaints were sent to us.
No.
Both complaints sent to us.
Tell us whose complaint is treated as,
Father of the deceased.
this is registered at what time?
11:45 PM.
11:45?
PM.
And now,
Next day, next day.
Yes, yes.
The night. The night, Mullah.
The night.
In the night. In the night, Mullah. In the
now,
night.
when is the body, one second, when is the body handed over to the parents for cremation?
Mullah, kindly have this
Just
note
tell
that
us,
I've given.
what
Just
time
take
is
a
the body
minute.
handed over to the parents for cremation? One second.
Around 3:30.
30:10.
No.
Therefore, one thing is very clear. The body is handed over to the parents for cremation at 8:30 PM. The FIR is registered at 11:45 PM. 3 hours and 15 minutes after the body is handed over to the parents for cremation.
They refused to file. Well, this is the problem. We handed it over. They filed the FIR. They made the complaint at 11:45. They say, we are in shock. Please do whatever you want to do. They wanted a postmortem. We did the postmortem. All is videographed. Everything is videographed.
The autopsy and the postmortem take place.
Between 1:45 to 4 PM.
Now, between 1:45 and 4 PM, the autopsy takes place, followed by the
My lord, the
postmortem.
autopsy took place at 6 o'clock, not at,
Fair enough. That's
Six.
all right. We'll take it as one between 1 and 4 o'clock. It doesn't take place in 1 minute. It takes
that was
time.
when,
Videograph.
1 second. Don't keep on interrupting.
They wanted
So
a board. We
are
constituted a
proceeding-
board.
We are proceeding on the basis of Mr. Sibal's hypothesis that the autopsy and the postmortem take place between 1 and 4:45 in the afternoon. Now,
Lordship, there is-
understand this. Clearly,
Lordship, there-
the autopsy would reveal that this is a case where a doctor has been murdered, where she has been murdered.
Yeah.
The FIR is registered at 11:45 in the night, Mr. Sibal.
Yeah,
And who was expected to
yeah.
Nobody in the hospital registers the FIR. The father registers the, what was the principal or the vice principal? What were the authorities of the hospital doing?
They wanted a board. We constituted a board. They wanted a magistrate. We got the
You
magistrate.
don't need
They realize
time
that
for
murder has
registration
been
of
the
FIR.
history of
You don't need a medical board for registration of FIR.
At the moment, Millers, what are we considering? We are considering, Millers, 2 or 3 things, as your lordship has put to me.
Not done.
How did these photographs reach the social media?
No,
That's, I'll mention all this, how did these photographs reach the media? We have nothing to do with it.
No, let
because
us
we
not
cordoned off
trivialize, my lord.
everything. People there took photographs, came in, took photographs and sent it. Number 2, Millers, number 2, immediately, Millers, immediately an unnatural death case, Millers, was started and an investigation was started. Your lordships may be right, Millers, why did it happen? But whatever the parents were doing, we were agreeing with that. We set up a board. We asked the magistrate to come, a judicial magistrate to be present. Everything was videographed. Everything was called.
Mr. Sibal, it is the
Application
obligation
was made
of the
before the Seattle
authorities
court.
of the hospital. The parents are not present in the hospital when the murder takes place.
Yes.
It's the obligation of the authorities of the hospital to register an FIR the moment they
2:45
realize.
it was done. 2:45 done. The letter was sent.
11:45 in the night.
No, 2:45 letter was sent. Assistant superintendent sent a letter at 2:45, Millers. It's not 11:30, at 2:45 itself, we'll set out all this, Millers. It's better we set it.
What we, Mr.
Lordships may give me 5 minutes, my lord,
Yes.
to further, my lord, to assist your lordships. My lord, first of all, Lord, let us not trivialize on this side, my lord, we are dealing with one incident, but your lordships are rightly looking at a larger picture. But we are dealing with, my lord, a young doctor, not only raped by a sexual pervert or perverts, but who was an animal-like instinct, who had an animal-like instinct, the way, my lord, the body was handled. Thereafter, my lord, I don't wish, my lord, to make this a political issue. I would request the state also not to be in a denial mode. 3 hours of the patient, parents waiting, my lord, is something we can experience if we put ourselves in that position. Now, my lord, so far as the safety is concerned, my lord, one thing I must bring to your lordship's notice. My lord, the doctors are genuinely, my lord, have a grievance. They are, my lord, they've lost one of their colleagues, my lord, globally. But, my lord, out of, my lord, all states, 23 states have legislations dealing with, my lord, what is called for, my lord, Kerala, my lord, so-and-so Medicare service persons and medical service institutions, prevention of violence and damage or loss to the property act. There are, my lord, I'll give, my lord, the list of acts. My lord, this also the National Task Force, my lord, can
The punishment which is provided under.
it's a cognizable, my lord, and
3 years.
3 years.
yes, my lord. It's cognizable, non-bailable, and punishment is 3 years. My lord, this is first. I'll, my lord, place it. The National Task Force, my lord, which our lordships contemplate, can, my lord, go into this, can even make suggestions, and it should be welcome, my lord. My lord, second thing, my lord, which is worrying us is this. My lord, even in a well-organized function, if we want the presence of 500 people in an auditorium, we all know we have to make efforts. 7,000 people at the middle of the night armed with lathis and hockeys, my lord, can never be without the knowledge, if not consent, of the police force. It's complete failure of law and order, my lord, in the entire state.
What time did the vandalization of the hospital take place?
Lord, midnight. It's at midnight, my lord.
I thought my
7,000
learned
people.
friend, he doesn't want to politicize the matter, my lord. Why is he saying all this?
Now,
Let's-
why this is, my lord, important.
We should be called upon. We'll tell you what happened.
Mr. Solicitor, what we'll do is that we'll.
One more aspect.
One-
One more aspect. Lord, and my lord, again, my learned friend may feel that this is, my lord, but this is directly related to the issue in question. Lord, the West Bengal has an in-charge DIG.
In charge?
In-charge DIG, Director General of Police, who is already being charged and being my lord, considered by your lordships for having fabricated or otherwise dealt with the evidence in Sharda scam case. My lord, your lordship's
Calcutta
direction
police
is
doesn't come under DGP.
Mr.
Calcutta police doesn't come under DGP. Why are you saying all this?
What this has to do
Lord,
then.
Director
Kolkata
General
police.
of Police
This has nothing
is
to
an
do with
in-charge
What is all
DGP.
this?
Charge
Not
of-
let someone else be the
This is
in-charge.
what is happening.
Let them choose, but not the man who is already
This is
accused
the
of
kind of
having.
misinformation we are having, my lord.
This is missing.
And
This is nothing to do, this is a
Nothing to do.
only a minute.
Malad, I have only one small request.
Another
What
minute.
what do you propose to do about the principle?
Whatever your lordship says, we'll do, Malad.
That has been constituted.
As a-
Malad, whatever your lordship says, we will do. There's no issue. SIT is constituted.
State, you must-
SIT is constituted, but whatever your lordships will say, we will do. We are not, Malad, this is not adversarial, as I said. Malad, just give me just 1 minute. I just handed over something to your lordship. Just have a look at it, Malad.
Depends on
Just
the.
give it to my lord.
Can
3
I
copies
only
that I handed.
All right, Mr. Sibal, we'll just hear the solicitor for a minute. He just wants a minute.
All
and then we-
Lord, I just, my lord, I want this, my lord.
Your lordship,
Lord,
may I
an
just submit?
in-charge
No,
DG who
wait.
is already a tainted officer in an affidavit filed before this court should be replaced by any other in-charge DG of their choice.
Malad, just have this.
Another,
We have
my lord.
we have set out what is in the media and we have set out the reality.
No, share it with
For-
all of us.
We will share it, don't worry.
No.
Kolkata police informed the family members that the present case
No,
was
they
a
are
case
in
of
a denial
suicide.
mode.
False.
No, another
False.
aspect.
At
My
no
lord,
time did
cast
the police give
judgment.
this information.
Presently, what we propose to do is, we'll indicate what the broad parameters of our intervention in this matter consists of. We'll just pronounce it very shortly. For one thing, Mr. Sibal, we are very, very concerned. Let not the power of the state of West Bengal be unleashed on peaceful protesters.
I give to your, we have videos of all that happened.
People, whether they are doctors, civil society, lawyers, people who are protesting, so long as there is no act of destruction of.
We have videos. We agree.
Let there not be the power of the state unleashed
Agree.
on peaceful protest.
Manoj, I agree, and that has not happened. 1 second. We have videos which we have placed, we will place before your lordship. And Manoj, what happens is political parties get into the act, and this is what happens.
People who are taking to the media to communicate their views.
Yes.
Let us deal with them with a great deal of.
I agree, I
It's a time of national catharsis.
Look at the girl, don't be in denial.
Manoj, now, for example, they say pelvic and collarbone was broken. False. Postmortem doesn't say that.
Lordship, state and the center, they'll keep arguing.
Fair.
CBI is investigating it.
Yes.
We will ask for a report from the CBI. Now, what we propose to is,
Just-
1 second.
Just one second.
This must stop. We are in charge of the proceeding. We have heard Mr. Solicitor, we have heard Mr. Sibal. If we start hearing all the interveners, there'll be no end to it.
Lordship,
Please have some patience. We are going to now tell you what we are proposing to do. We are not disposing of the case, but let's allow us to at least pronounce what we intend to all right.
This is the list of acts.
Would your lordship just
Sorry,
pause a minute?
On 9 August 2024, a 31-year-old postgraduate doctor at R.G. Carr Medical College Hospital, Kolkata, who was in a 36-hour duty shift, was raped and murdered inside the seminar room of the hospital. As horrific details have emerged in the course of media reportage, the brutality of the sexual assault and the nature of the crime have shocked the conscience of the nation. The name and graphic images of the deceased have been widely circulated on social media without regard to her privacy or dignity. Writ petitions were instituted before the Calcutta High Court seeking, among other things, a court-monitored investigation of the crime and the conduct of the hospital authorities, including the role of the principal of the medical college and other officials by a special team of investigating officers. It has been alleged that the parents of the deceased were initially informed that their daughter had committed suicide. They were permitted to see the dead body after several hours, and a first information report in regard to the murder was registered belatedly by the police after several hours. By its order dated 13 August 2024, the High Court transferred the investigation to the Central Bureau of Investigation. Following the incident, agitations and protests were called by doctors' associations, student bodies, and civic groups across the country. On the eve of Independence Day, several areas in Kolkata saw protests spurred by the Reclaim the Knife campaign. At 12:30 a.m. on 15 August, when a protest was underway at the hospital, a large mob assembled at the premises of the R.G. Carr Medical College Hospital and vandalized the emergency ward and other departments of the hospital. Following the acts of wanton disruption and vandalism, the Indian Medical Association, a private and voluntary organization of doctors in India, called for a nationwide withdrawal of medical services except emergency services for 24 hours on 17 August 2024. In the aftermath of the brutal incident and the demonstrations which followed, the state government was expected to ensure the deployment of the state machinery to prevent a breach of law and order. It was all the more necessary to do so since investigation of the crime which took place in the precincts of the hospital was underway. We are unable to comprehend how the state was not prepared to deal with the incident of vandalization of the premises of the hospital. Nationwide protests following the brutal incident in R.G. Carr Medical College Hospital have brought the issue of the lack of institutional safety for doctors to the forefront. Medical associations have consistently raised issues of the lack of workplace safety in healthcare institutions. Medical professionals, in the performance of their duties, have been unfortunate targets of various forms of violence. Hospitals and medical care facilities are open throughout the day and night. Medical professionals, doctors, nurses, and paramedic staff work round the clock. Unrestricted access to every part of healthcare institutions has made healthcare professionals susceptible to violence. Patients of relatives in anguish are quick to attribute untoward results to the negligence of medical professionals. Such allegations are immediately followed by violence against medical professionals. In May 2024, two on-duty doctors were allegedly attacked by relatives of a patient who died during treatment in a hospital in West Bengal. In another incident in May 2024 in Bihar, following the death of a 25-year-old pregnant patient, a nurse was allegedly pushed off the first floor of the building by the kin of the patient. In August 2024, a final year resident in a hospital in Hyderabad was allegedly assaulted by a patient's attendants after the patient died due to medical conditions. These incidents of violence are a few among the many that have been unleashed against members of the medical community in the recent past. They are portents of a systemic failure to protect doctors, nurses, and paramedical staff in the confines of hospitals. With few or no protective systems to ensure their safety, medical professionals have become vulnerable to violence. With the involvement of systemic issues for healthcare across the nation, this court has had to intervene. Women are at particular risk of sexual and non-sexual violence in these settings. Due to ingrained patriarchal attitudes and biases, relatives of patients are more likely to challenge women medical professionals. In addition to this, female medical professionals also face different forms of sexual violence at the workplace by colleagues, seniors, and persons in authority. Sexual violence has had its origins even within the institution, the case of Aruna Shanbag being a case in point. There is a hierarchy within medical colleges, and the career advancement and academic degrees of young professionals are capable of being affected by those in the upper echelons. The lack of institutional safety norms at medical establishments against both violence and sexual violence against medical professionals is a matter of serious concern. While gendered violence is the source of more malevolent manifestations of the structural deficiencies in public health institutions, the lack of safety is of concern to all medical professionals. Preserving safe conditions of work is central to realizing equality of opportunity to every working professional. This is not just a matter of protecting doctors. Their safety and well-being as health providers is a matter of national interest. As more and more women join the workforce in cutting-edge areas of knowledge and science, the nation has a vital stake in ensuring safe and dignified conditions of work. The constitutional value of equality demands nothing else and will not brook compromises on the health, well-being, and safety of those who provide healthcare to others. The nation cannot await another rape or murder for real changes on the ground. Several states, such as Maharashtra, Kerala, Karnataka, Telangana, West Bengal, Andhra Pradesh, and Tamil Nadu, have enacted legislation to protect healthcare service professionals from violence and damage to property. All these enactments prohibit any act of violence against medical professionals. The offense is non-bailable and punishable with 3 years of imprisonment. However, these enactments do not address the institutional and systemic causes that underlie the problem. An enhanced punishment without improving institutional safety standards falls short of addressing the problem effectively. We have attempted to flag here the ground reality indicating the lack of institutional safety standards in healthcare institutions. A non-exhaustive formulation is set out below. A. Medical professionals who are posted for night duties are not provided adequate resting spaces. More often, doctors rest in the patient's room or in available public spaces. Duty rooms are scant. Separate duty rooms for male and female medical professionals are conspicuous by their absence in most healthcare establishments. B. Interns, residents, and senior residents are made to perform 36-hour shifts in conditions where even basic needs of sanitation, nutrition, hygiene, and rest are lacking. There is an absence of uniformity in terms of a standard national protocol. The fear of retribution prevents most healthcare professionals from questioning the absence of facilities for basic well-being. C. Lack of security personnel in medical care units is more of a norm than an exception. More often than not, medical professionals, which includes young resident doctors, interns, and nurses, are left to handle unruly attenders. Open access to healthcare facilities leaves medical professionals vulnerable to undesirable elements. D. Medical care facilities do not have sufficient toilet facilities. Most often, there is only one common toilet for medical professionals in one department. E. The hostels or places of stay for medical professionals are situated far from the hospital. Doctors and nurses who have to travel to and from the hospital are not provided transport facilities by the institution. Even within the precincts of the sprawling spaces of public hospitals, there is either inadequate or no transportation facilities for the safe commute of professionals. F. There is an absence or lack of properly functioning CCTV cameras to monitor ingress and egress to the hospital and to control access to sensitive areas. G. The patients and their attenders have unrestricted access to all places within the hospital, including intensive care units and the doctor's resting rooms. H. Lack of screening for arms and weapons at the entrance of hospitals. I. Dingy and ill-lit places within the hospitals. J. Medical professionals have to shoulder the responsibility of being both medical and emotional caregivers to patients and their relatives. There are no supportive facilities and no training and communication skills. And K. Certain spaces within hospitals, such as the intensive care unit and the emergency wards, are prone to a greater risk of violence because of the severity of medical conditions of patients in these departments. We have, in this backdrop, formed the view that a national consensus must be evolved after due consultation with all stakeholders on the urgent need to formulate protocols governing the issues which this order has highlighted. We have attempted to compose for this purpose a diverse body of persons with experience in healthcare institutions. A national task force with the following members of the medical profession is hence constituted. 1. Surgeon Vice Admiral Aarti Saryan, AVSM, VSM, Director General Medical Services, Navy. 2. Dr. D. Nageshwar Reddy, Chairman and Managing Director, Asian Institute of Gastroenterology and AIG Hospitals, Hyderabad. 3. Dr. M. Srinivas, Director, All India Institute of Medical Sciences, AIIMS, Delhi. 4. Dr. Pratima Murthy, Director, National Institute of Mental Health and Neurosciences, NIMHANS, Bangalore. E. Dr. Govardhan Dutt Puri, Executive Director, All India Institute of Medical Sciences, Jodhpur. 5. 6. Dr. Soumitra Rawat, Chairperson, Institute of Surgical Gastroenterology, GI and HPB Oncosurgery and Liver Transplantation, and Member Board of Management, Sir Gangaram Hospital, New Delhi, and Member Court of Examiners of the Royal College of Surgeons, England. 8. Professor Anita Saxena, Vice Chancellor, Pandit B.D. Sharma Medical University, Rohtak, formerly Dean of Academics, Chief Cardiothoracic Center and Head Cardiology Department at the All India Institute of Medical Sciences, Delhi. 9. Dr. Pallavi Saple, Dean, Grant Medical College and Sir J.J. Group of Hospitals, Mumbai. And 10. Dr. Padma Srivastav, former professor at the Department of Neurology, AIIMS, Delhi, currently serving as the Chairperson of Neurology at Paras Health, Gurugram. The following shall be the ex officio members of the NTF. A. The Cabinet Secretary to the Government of India. B. The Home Secretary to the Government of India. C. The Secretary, Ministry of Health and Family Welfare, Government of India. D. Chairperson of the National Medical Commission. And E. President of the National Board of Examinations. The NTF shall formulate effective recommendations to remedy the issues of concern pertaining to safety, working conditions, and well-being of medical professionals and other cognate matters highlighted in the above segments of this order. The NTF shall, while doing so, consider the following aspects to prepare an action plan. The action plan may be categorized under two heads. 1. Preventing violence, including gender-based violence against medical professionals. And 2. Providing an enforceable national protocol for dignified and safe working conditions for interns, residents, senior residents, doctors, nurses, and all medical professionals. 1. Prevention of violence against medical professionals and providing safe working conditions. A. Ensuring due security in medical establishments. 1. Triaging departments and places within the hospital based on the degree of volatility and the possibility of violence. Areas such as emergency rooms and intensive care units are prone to a greater degree of violence and may possibly need additional security in place to deal with any untoward incident. 2, a baggage and person screening system at every entrance of the hospital to ensure that arms are not carried inside the medical establishment. 3, preventing intoxicated persons from entering the premises of the medical establishment unless they are patients. And 4, training security personnel employed at hospitals to manage crowds and grieving persons. B, infrastructural development. 1, provision of separate resting rooms and duty rooms in each department for A, male doctors, B, female doctors, C, male nurses, D, female nurses, and E, a gender-neutral common resting space. The room must be well ventilated, have sufficient bed spaces, and provide a facility for drinking water. Access to these rooms must be restricted through installation of security devices. 2, adopting appropriate technological intervention to regulate access to critical and sensitive areas, including through the use of biometric and facial recognition. 3, ensuring adequate lighting at all places in the hospital, and if it is a hospital attached to a medical college, all places within the campus. 4, installation of CCTV cameras at all entrance and exit points of the hospitals and the corridors leading up to all patient rooms. And 5, if the hostels or rooms of the medical professionals are away from the hospital, provision of transport between 10 p.m. to 6 a.m. for those who wish to travel to or from their place of stay to the hospital. C, employment of social workers trained in grief and crisis counseling at all medical establishments. D, conducting workshops for all employees of medical establishments, including doctors, nurses, and helpers, on handling grief and crisis. E, constitution of employees' safety committees composed of doctors, interns, residents, and nurses at every medical establishment to conduct quarterly audits on institutional safety measures. F, including additional requirements on institutional safety measures for medical professionals as a criteria for accreditation of healthcare establishments by the National Accreditation Board for Hospitals and Healthcare Providers. And G, the possibility of establishing police posts in medical facilities commensurate with the footfall, bed strength, and facilities. 2, prevention of sexual violence against medical professionals. A, the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013 applies to hospitals and nursing homes, including private healthcare providers. In terms of the provisions of the Act, an internal complaints committee must be constituted in all hospitals and nursing homes. B, the duties of an employer listed under Section 19 of the Sexual Harassment of Women at Workplace Act 2013, which includes organizing sensitization programs and providing a safe working space, must be discharged. And C, ensuring for every medical institution a helpline number for medical professionals, which is open 24/7, and emergency distress facilities. It is clarified that the phrase medical professionals used in this judgment encompasses every medical professional, including doctors, medical students who are undergoing the compulsory rotating medical internship as a part of the MBBS course, resident doctors and senior resident doctors and nurses, including those who are nursing interns. The phrases medical establishments, hospital, medical institutions are interchangeably used. The NTF shall be at liberty to make recommendation on all aspects of the action plan highlighted above and any other aspects which the members seek to cover. They are at liberty to make additional suggestions where appropriate. The NTF shall also suggest appropriate timelines by which the recommendations could be implemented based on the existing facilities in hospitals. The NTF is required to consult all stakeholders. Bearing in mind the gravity and urgency of the situation, we have included the heads of the National Medical Commission and the National Board of Examinations as ex officio members of the NTF. Bearing in mind the national concerns which have been raised over the issue and the high priority which must be given to the creation of safe working conditions in healthcare institutions, we request the Cabinet Secretary to the Union Government to associate with the work of the NTF. The Home Secretary of the Union Government has also been made a member of the NTF in order to facilitate proper coordination with the state governments. The Secretary to the Ministry of Health and Family Welfare of the Government of India will be the Member Secretary of the NTF. The Ministry of Health and Family Welfare will provide all logistical support, including making arrangements for travel, stay, and secretarial assistance, and bear the expenses of the members of the NTF. The NTF is requested to submit an interim report within 3 weeks and the final report within 2 months from the date of this order. All state governments and union territory governments, through their secretaries in the Ministries of Health and Family Welfare, and the central government, through the Secretary Union Ministry of Health and Family Welfare, must collate information from all hospitals run by the state and by the central government respectively on the following aspects. A, how many security personnel are employed at each hospital and each department? B, whether there is a baggage and person screening mechanism in place at the entrance of the medical establishment. C, the total number of resting/duty rooms in the hospital and specific details of the number in each department. D, the facilities provided in the resting/duty rooms. E, information on whether all areas of the hospital are accessible to the general public, and if so, with or without any security restrictions. F, whether there are CCTV cameras in the hospital. If there are, how many and in which locations? G, whether the institution provides medical professionals training to appropriately handle the grief of patients. If so, the details of the training must be provided. H, whether social workers who specialize in handling grief of families of the patients are employed at the hospital. If so, then total number of social workers must be provided. I, whether there are police outposts within the premises of the hospital or the medical college hospital campus. J, whether an internal complaints committee in terms of the Sexual Harassment of Women at Workplace Act 2013 has been constituted. And K, whether the employer of the establishment has discharged the duties prescribed by Section 19 of the Act of 2013. If so, the details of it. The data submitted shall be tabulated and filed with an affidavit by the Union Government within 1 month from this order. The Central Bureau of Investigation shall submit a status report to this court by, we'll say 22nd and not 23rd, by 22nd August 2024 on the progress in the investigation of the crime at RG Kar Medical College Hospital. The state of West Bengal shall also file a status report by 22 August 2024 on the progress of the investigation on the acts of vandalism which took place at the hospital in the aftermath of the incident. The matter will now be listed on 22 August 2020.
Only one request. What is shared by the state of West Bengal with your lordships be given to CBI. We also need, like, have it. They cannot have any objection.
1 second, I can just say, when that is.
Lord, what is shared by...
My lord, can I just add one thing, my lord?
Only what is shared...
Principal of the college, is he now under suspension? Is he on long leave? What is that?
He's on leave. He's on leave. High Court order is Miller's operative. He's on leave. He's on leave. There's an SIT constituted also for all kinds of things.
My lord, can I?
Lords, I would...
Anywhere, right?
No.
But can I add one
That's
thing?
why I said, Miller, whatever your lordship says, we'll abide by it. That's not enough.
Whatever is shared
My-
with your lordships, Lord, the CBI must be
Yeah.
given.
No, we will file an affidavit.
But you have shared something with the
One
court, you
second.
can't
No,
have
no,
any
no.
objection.
At not this point, Mullahs. In
Lord,
fact, what
no,
is
I am
happened-
on that point
What
first.
happens is, Mullahs, this goes to them, then the social media takes action. It'll
No, there was
exacerbate the
CBI.
situation. This is only to inform your lordships, Mullahs, that what's in the social media is not correct, and what's happening is just contrary to
Why
what the
can't you
record is.
share with
For
CBI?
example, they say it's a suicide. It is not a suicide. We never said.
Tainted.
We will, but Mr. Sibal, there was undoubtedly an unexplained delay.
I am not on merit.
Yes, Lord.
I am not on
What
that.
is to hide from CBI?
Mullahs,
Lord,
one
this-
second.
This shows we are
One
not
second,
getting
I
cooperation.
am not on that, Mullahs. Mullahs, as I said, whatever needs to be done must be done. People must be convicted. There is no issue on that. It's just that I don't want, Mullahs, another kind of tirade in the social media.
No, it
Mullahs,
will not be. You give it to
will be, it will
CBI.
be.
You
I
have
know
submitted
it.
to give it to CBI.
One more thing. The state must ensure that those who practiced acts of vandalism and
Absolutely.
Yes.
We have lodged
37.
37 already arrested, 50 FIRs filed. 37 already arrested.
50 FIR for one incident. It's a recipe for not investigating.
You have, 1 second, you have a copy of the, before we part to the matter for today, you have a copy of the autopsy report here?
Yes.
We have it. We have it.
I have.
We hand it over. Yes. In the meantime,
My
can
lord,
I add
would,
one
my lord,
thing? my lord?
again request, my lord, if your lordships have seen something, your lordships have, my lord, the CBI must be given, it will remain, my lord, confidential. But we must cross-check what is given to
My lord, your
you.
lordship.
This resistance shows that there is a lack of
No,
cooperation.
no, obviously there is a lack of faith.
My lord, your
Do
lordship.
that on that day, Mr.
Only 1 second, my lord.
Day after tomorrow.
Give
My lord,
the entire thing.
today, my lord, they can give me today. My joint director is here. I'll give it to her.
Oh, yeah, allow, yeah. Just allow. Yes. Yeah, yes. Now, my
What
lord,
is there to hide from
one
CBI,
second,
my
one
lord?
second.
If they have given
Nothing is-
something related to crimes,
Yeah.
it must be given, my lord, to the
Kindly
CBI.
see, kindly see page 40. Kindly,
Don't read it aloud, we'll just.
kindly page 40.
Right. शुरू करें स्टेट को बोलो काम शुरू करें
Yes, yes, I know.
स्टेट को बोलो काम शुरू करें
Hmm. Explain this. I'll just say, read. Outside.
Only know, my lord, what is being shown to your lord.
It's the post-mortem report, which is in the
Say
case
that,
diary.
I asked you 4 times, what is the, why hide this?
Yes, I'll give he has case diary, has it, my lords. Post-mortem report is there. I don't know why I'm showing nothing else.
Case diary has been handed over to the
Handed over
CBI.
to the CBI.
The entire case diary, inclusive of.
Yeah, inclusive of
Ah,
this.
there.
for the safety of lady dog.
She's not a lady.
Inquest report. Yes, we have. Give the entire thing to, yes. Please give it to my lord.
Just get the whole copy. Right up now. Same copy.
3 copies, please.
Just put a flap on that inquest report.
Please, put a flag, please.
If you can share that, I have it, but just if you can share it with me.
Put a flag,
Mr.
put a
Sibal
flag.
neither says yes nor say no, but doesn't give, my lord. That's the stand he has adopted from the
You can
day one.
continue to say that. You can continue to say that. You will say, I know
Yes, my
you'll
lord,
repeat
it is a
it.
test
And I
whether
know-
the
and
state wants
why do you
to
want
come
to-
clean
One
or
second, just
still
one
play hide and seek.
Please.
I don't know why my learned friend.
You know why I am saying.
I know why you are asking.
Yes.
Yeah. Yeah, we've seen.
Wait.
Huh?
Give a soft copy.
You hand over the compilation to us. Hand over the compilation.
Give us the.
Compilation and educate.
No, you don't have it on your.
Give us.
We're locating the soft copy.
Whatever we have received, we'll file with our report.
What is that? What is that?
Compilation.
List of deeds.
This was the Calcutta petition.
Report, Malaz. Do you have a soft copy? If you can give it. Let's see if you have a soft copy.
Hard copy we had.
Here it is.
This is the inquest report.
This is the inquest report. This is it, Malaz.
Check 1, 2, 3, 4. Check.
What is also not true?
Stay in the barracks of the 4th Battalion.
Trying to live or associated smothering and not unconsidered in nature, also verbally opined that evidence of forceful penetration, insertion in a area, possibility of sections.
stage so far?
In the rape case,
In
one.
the rape case, one, my lords. Main accused, the main accused. He was a civic worker, my lords, and his Bluetooth was found at the spot. My lords, therefore, we connected it with the mobile. And the CCTV also footage was there, so we connected it. We went to him and we realized, my lords, what had happened, my lords, that he along with one Mr. Bhatta, very interesting, my lords, was
Lord,
talking up.
Whenever your lordship finds CBI.
My lord, I just need 10 seconds.
Saurabh Bhattacharya, he was, let me just explain. What, yeah, it's a case diary, you have it all.
Only 10 seconds, my lord.
My lord, just allow me, allow me.
Lord.
What had happened?
Same comprehensive
One
issue on which
second.
your lordships are perfectly framed. This deliberation and this exercise took place between 2016 to 2018 for preparing some protocol and some law. My lord, it resulted into framing of a legislation in 2019. Draft legislation is with me, with the central government forming a committee with IMA and other stakeholders. They gave a report. Report resulted into a draft legislation on violence against, my lord, medical practitioners and medical establishment. It is pending. IMA, my lord, represents the entire community of doctors. So if your lordships consider it appropriate, they can contribute in the participation of the committee, my lord.
Mr. Mahendra Singh, we have already said
Your
that we will consult all stakeholders.
Correct, that's
We have-
what your lordship said.
And we have specifically referred to IMA.
May I just add, my lord, just wanted that this particular exercise, to whatever it's worth, my lord, is there. And if your lordship could consider, my lord, they can also two nominees to work with them. That's all. I'm not saying anything more.
You can write to the Secretary Ministry of
very
Health
well.
and Family Welfare, so
I
that the
will.
committee will consult IMA. We have in fact referred to the role of IMA.
Very
My
well.
lord, in
I'll do it.
addition to what
Great.
Mr. Mahendra Singh has said, my lord, then can I just add, my lord? My lords have said, my lord, there are 3 legislations we have tabulated, my lord.
No, we have not said chief.
3 or Lord, for 23 legislations. I'm
We
sorry.
have said several states,
Yes, that's what
including.
your lordship has said.
My lord, we have tabulated 23, but none of them has preventive measures. My lord, there is 2 more.
Sorry, that's not inconsistent with
My lord,
what we have said.
no,
We have
there-
said several states, including.
My lord,
that-
only two more suggestions, my lord, if your lordship consider it appropriate to include, my lord. One is institutional FIR, my lord, must be lodged within the 2 hours of a cognizable offence happening within the incident. One, my lord. Second, my lord, if your lordship kindly permit me, a distress call system, my lord, may be available.
We have already referred to that.
It is to the
We
women.
have specifically referred to
That's
it.
it, my lord is already ready.
Can I just?
Your lordship, we are for the women doctors, young doctors, your lordship. What we request, your lordship, if we can have a software mechanism system where a distress call alert can be linkaged with the police station.
This can be suggestions
Hereby.
for the
And
task
secondly,
force.
your lordship, if we can
You're
have a
absolutely right.
proper functioning of CCTV cameras inside.
We have done this.
Right. In fact, we have flagged these very issues.
Yes, yes. We've done a mobile app, we've done a,
The protectors need to be protected, your lordship's
Order. This one second. One second. You haven't filed a PIL this time? Every week from you. A list on 22. We expect that the government of West Bengal shall observe necessary restraint in the face of peaceful protests conducted by any quarter of civil society bearing on the issues which form the subject matter of the incident which took place in Kolkata. To stop. The necessary, it shall be ensured that the power of the state is not unleashed either against persons using legitimate means to express their opinions or to participate.
yes, yes, no doubt, my lord. Except that
The doctors' protest must be burned, my lord. They leave the OTP and all treatment and they get the.
Since this court is seized of the matter pertaining to the safety and well-being of all medical professionals at their workplaces as an issue involving high national priority, we would request all the doctors who are abstaining from work across the country to resume work at the earliest.
Lordships, may I come in with your lordships? Please, your
The earliest. Full stop. Above all, the abstention from work of doctors affects those segments of society who need medical care, medical care the most from accessing health-related services. Full stop. the abstaining doctors and medical professionals stand assured that their concerns are receiving the highest concern from the Supreme Court of India. But besides, their concerns are already being portrayed before this court by a diverse range of counsel on both sides.
Deeply obliged.
I'm talking about the women doctors of the place where the incident has happened. Now, Lordships, it's very important. I'm sorry for Lordships insisting over and over again, but Lordships, I think it's of some importance in the matter. So, Lordships, the day on 14th August night, the day the attack took place on the doctors, when the protesters were on the site, the same hoodlums, they went to the hostel. They actually threatened the lady resident doctors, and they were threatened with the kind of threat that's given to women every time they protest. And Lordships, very harsh things and they were threatened with very harsh consequences. Now, Lordships, now the women doctors, subject to, this is what I've been instructed by an association of doctors in West Bengal, and they are in touch with the resident doctors. They said that the women's hostel, most of the women, they've been called back by their parents because they're not feeling safe. So your Lordships, when your Lordships say they should join this, and because on that very date, the police, the state police, they ran away from the scene. Lordships, it's widely reported. I don't need to emphasize. Just
Life in West Bengal.
Lordships,
I'm not making it political. It's my lord.
He's appearing for the doctors. Yes, ma'am.
Yes, Lordship. So what happened is So what happened, the police just left them, and the police hid in the changing room of the nurses. This is what the doctors told me, Lordship. Now, if I don't want to be caught between the political battle of these two sides. Now,
there is no political battle.
Let me just explain. So what I'm just for the students and the doctors practicing, the Association of Doctors. In fact, one doctor, a very brave doctor, I don't want to take the gender. So it gave a representation to the police. So a lot of people have given a representation of the police. They have asked me to forward it to your Lordships in sealed envelope. I have 3 copies of the representation. Lordships may just have a look to see what is the position of the doctors there.
Lord, I can make it clear, my lord, we do not make this political, but we also receive, my lord, complaints. This is the hard reality on ground. My learned friend is not keeping mum for no reason.
What is all this going on? I'm not keeping mum for no reason.
Therefore, is not sharing anything with the CBI.
We've given the entire case diary. What more do you want?
Is this hostel a part of the hospital, or it is at a far off place?
Yes, within the campus.
I was told that one set went to the hospital when they ransacked. Some goons, they went to the hostel.
Ladies hostel, and then the lady doctors hostel and male doctors hostel, they are all different.
I assume so, Lordship, because they said that one set.
How many doctors, intern doctors are there in the hostel today?
Lordships, I am told.
How many were actually?
I am told 90% of the women doctors are not there.
In numbers, how many
were there in the hospital?
There, and how many have left now?
Lordships, I'll just take the information.
Ask
right
someone
now. Just
who knows about it.
Mr. Sybil, this is very serious.
Very serious, of course. No doubt about it.
What is the police? What is the police?
No, I agree, my lord. So
Tip of an iceberg, my lord. I don't wish to.
That is why FIRs have been registered. We'll take strong action. We have got from the CCTVs, photos have been from the CCTVs, photos have been identified, and we have lodged FIRs, and we are taking. Those people have been arrested. 37 people have been arrested.
But Sybil, arrest is another thing.
Yeah.
Obviously, there were protests of the doctors.
Yes, of course.
This was part of the wider protests which were going on that night.
Absolutely.
It was called Reclaim the Night.
Yes.
The West Bengal government could not have been unaware of the fact that when there are protests across the country, there's always another segment which will try and disrupt this.
What?
The women the women doctors are assaulted. The police run away from the scene. Thereafter, the women doctors are called out by name, namely the people who are leading the protest, and they were threatened with the same fate that has befallen the others.
Well, if they tell us, we'll take strong action. Mother, I agree. I'm not disputing.
You are supposed to be
Mother,
aware.
hold on. My Lord is asking me and let me respond.
What was the police,
What is that,
what was the
Yellow?
police force doing in anticipation?
What happened was there were 150. What's it? There were 100. Hold on. Allow me. Mr. Sitter, sir, I don't.
Please don't interrupt, Mr.
Yes,
Sitter. We are putting a point to him.
And as I said, Mothers, we are on the same side in this, Mothers. Now, there were 150 policemen. Mothers, what happened was that outside the hospital itself, 150, in anticipation, 150 policemen. But Mothers, what happened was 7,000 people came. By the time we got additional force, which came later, this vandalism took place. This is what happened.
You 7,000.
We picked them up. We picked them up from there, Mothers.
It doesn't appear that 7,000 people vandalized the place.
No, they didn't.
It appears
I didn't say that. Because by the time
80 to 90 people, they indulged in vandalism.
we have the video, but we'll show it. There's no issue on that.
And
Facts can't be, Mothers, distorted.
did the police run away from the site?
No, that can't be, Mothers. We'll find out. How can the police run away?
Police not
No
knowing
police run away, Mothers. These allegations, if you take them,
Impossible.
Mothers, as face value,
Impossible, Mothers.
then we have a problem. We have a video. I'll show it to you, Your Honor.
We don't want
Can we show you the video?
we
You have to send them for
We
vandalism.
don't want to disclose the name or even the designation of the person who has written it. But please rest assured that this is not an ordinary complaint which has been,
No, I agree,
which has been
Mothers.
submitted.
Mothers, see the video. We'll show.
Lord, please do not disclose. He or she will meet with the same fate.
Police caused the protesting doctors, threatening them.
Just see, Mothers. We've got the video. It's pen drive also. We can give it to you. There's a pen drive. We can give you the pen drive.
Mr. Sibal, this email was sent on 19th of August by this particular doctor to the
Just give it.
ID of the Kolkata police
Lordships, it's been sent
at
yesterday.
22 hours.
Yesterday, Mother.
But therefore, tell us one thing, what is the police doing?
Mother, it was sent yesterday. We are taking action. We have taken action. See the video, Mother.
Which
just see
doctor,
the video.
which mail, how do you know that it is yesterday?
See the video, Mother. It's better. 150 police officers were camping outside. Kindly see the video, Mother.
Sir, Mr. Sibal,
Mother, I'm not here to defend anybody. Please make it rest assured, Mother.
look at it from a different angle.
Yes.
You made a fervent appeal to these doctors.
Yes.
Please join your duty.
Correct.
The marginalized section of the society is suffering.
Absolutely.
They can't afford to go to.
I agree entirely.
Now, these doctors, the lady doctors who are in the hostel, even if we ask the government to provide them with police protection, this police is going to protect.
No, Mother, we'll make sure.
That is our grievance.
Trust what
So
police.
at the RG Kar Medical College and Hospital, because obviously the women doctors have left for the reason that they are fearful of their safety. If the premises of this hospital have to be safeguarded for these doctors to resume duty, who is going to provide security at the premises?
Mother, we give an undertaking to this court.
CISF
We'll
security.
give an undertaking to this court. We'll give an
Let it be
undertaking.
CISF.
What we suggest is this, because if conditions return to normal,
We'll put additional,
if conditions return to normal at this hospital
yes.
and doctors start coming back, this will have an impact on the rest of the.
Of course,
Yes.
of course.
Therefore, why does we propose that let the CISF provide security at
Yes.
the premises
Yes.
of this hospital?
And Manoj, one more thing.
I have no problems with that.
Manoj, one more thing.
Idea is
Now
that their
that-
security is paramount. So please, if your lordship wants.
Manoj, now one more, Manoj, I am inviting this order. The person who has complained, Manoj, we do not know. But the state possibly knows. They say that the email was received at 22. Let that person be given special security by the CISF. Now the state knows about the person.
We will do it.
They don't want to reveal their identity.
You can't say whether the state police is incapable of all this.
100 and- no.
Here the matter of.
Lordship, 105 complaints have gone.
Many, did you get the figure?
Yes, your lordship. So there are 700 residents, 250 ladies, and only 100 are there now.
250.
250.
30 to 40 female. Then 50 have left.
Yes.
One-
Yes, your lordship.
100.
Approximately 30. 30 to 40 female residents and 60 to 70 male residents remain. Everybody else has gone.
32.
Lordships, I am told 30 to 40 female residents and 60 to 70 male residents remain. Rest have all fled.
Lord, we have this information.
Total 700.
Lord, when I said there is no law and order, it was
Emergency
not a political statement. We have this information and more.
Yeah, I'm sure you have.
This is the situation on ground.
Just 1 second. On the night of 15 August 2024, at midnight on 15 August 2024, when acts of wanton vandalization of the premises of the RG Kar Medical College Hospital took place, a mob of persons is alleged to have systematically attacked the male and female doctors, emergency hospital staff, and hostels. To stop Ms. Saprajita Singh, Senior Counsel appearing on behalf of the resident doctors, has placed on the...
I'm not on the resident. I'm for organization of doctors from West Bengal because they are too small. They're too to come
for an organization of doctors from West Bengal.
Protect the warriors.
Has placed on the record a copy of an email addressed on 19th August 2024 by a senior resident at the Medical College Hospital, setting out the details of the incident which took place. The court has been apprised of the fact that there were approximately 700 resident doctors at the RG Kar Medical College Hospital. Following the incident which took place on the night of 15 August 2000, on the night between 14 and 15 August 2024, most of the resident doctors have left their place of duty, as a consequence of which approximately 30 to 40 female doctors and 60 to 70 male doctors have only remained in their hostels. It is essential to create safe conditions for the doctors to return to their duties so as to enable them to not only pursue their duties, not only to pursue their own education, but to administer medical care to their patients. Accordingly, the court has been assured by Mr. Tushar Mehta, Learned Solicitor General of India, that the Central Industrial Security Force shall be deputed in sufficient strength. So, Central Reserve Police Force shall be deputed in sufficient numbers to guard the facilities of the RG Kar Medical College and Hospital, including the hostels where the resident doctors stay. Mr. Kapil Sibal, Learned Senior Counsel appearing on behalf of the state of West Bengal, states that there is no objection to such a course of action being adopted so as to bring security to the
Well, then they'll be responsible. I'm sorry to say, they'll be responsible, Manoj, because there are two kinds of forces can't be there, Manoj.
With the provision of central security.
Is it an information or a
We
threat?
hope and trust that the doctors will resume duties at the earliest. Any concerns which they may have in regard to their safety may be placed in the form of an email jointly addressed by the doctors to the Registrar Judicial of this court for further necessary directions.
But I have one additional submission to make. CBI is not now inquiring about the activities of the principal. On the wake of it, the state government.
We share this email with the solicitor. This email, please, and keep it in because we don't
It would be kept in confidence,
want the doctor to be targeted.
No, otherwise but now state of course knows, the state police would know because they have received, but I will keep it safe.
The state has constituted a seat for the which is CBI.
Lordships, we have assured the doctor, sorry.
Yes, he is on the matter that we'll deal with on.
We have assured the doctor
Mr.
the name
Solicitor,
will
please
not.
look at the solicitor. Please look at the designation of that person who was submitted. Just look at the designation of the.
I will. Right now I'm not, my lord, seeing that.
Yes,
Take it up on Thursday morning now.
no problem, no problem.
Possible to file in sealed cover, whatever.
All the petitions.
Schedule to do that on Thursday. If there's some concern, please come back to us.
Lordships.
We'll assure the doctors all over the country that whatever concern they have, please place it before us to
We are most grateful.
counsel over here.
Your
We'll
Lordship.
assuage your grievances the extent that we can. I'm sure this is a complete non-adversarial procedure.
Absolutely non-adversarial. We are grateful your lordships have taken up.
We'll have to file a status report. Your Lordship,
this on
easier
Thursday.
if we have it on Friday morning, Mulad.
Friday, this bench in this combination is not available.
Can it be Monday? We also get some time to prepare the status report.
Thursday morning.
We'll hand it over on Thursday morning, Mulad.
Goes to Tuesday then. So
No,
that's
but
why
no, we'll hand it over on Thursday morning then, Mulad, the status report.
Can it be Tuesday, Manu?
We'll keep it on Thursday.
With-
Thereafter, we'll keep it on Tuesday. We'll have a brief hearing on Thursdays.
Yes.
Monitor the situation across the country and then place it on Tuesday. But you can give us your status reports even by Thursday morning. There's no difficulty.
All petitions may be listed. All petitions. Now, if it was not taken on because it was filed late, no, it may be. So all petitions. By delivery, it also.
We are grateful.
Guys, grateful to it.
Check, 1, 2, 3, go, check, check.
Well, it's item 34 on your lordship's board, Malad, is that reservation matter, Malad, which the High Court, Malad, struck down the reservation.
The government to disclose.
Yes, so we have done everything, Malad. So if your lordship can take it up today, otherwise on Friday, Malad, because we need a stay, because scholarships have to be given, Malad, NEET examinations have to be sat. Without those certificates, it's not going to be possible.
The only thing is that to do that, I have to do something contrary to my own innate character, which is I have to be ruthless with disposing of matters. So I'm reached 34 today, yes.
Which, Friday then, Malad?
Sorry?
Friday?
Friday, this combination is not sitting. Thursday we are sitting.
Oh, Thursday.
But let's take a chance today. We'll quickly run through the board. Otherwise, Thursday we'll take it up.
In fact, very well. We wanted to, Lords, in fact,
yeah.
Because, Lords, the urgency is this, they served it on us. We had the break. We want to file a response to that affidavit. Can you, Milord, Monday?
Milord, your Lordship will hear us first because, Milord, as far I appear for the Commission, Milord.
Appearing on this side or?
This side, Milord, for the Commission. And the reason why there is some urgency is, Milord, people are lining up, Milord, to get their authentication done. So your Lordship's order will decide that.
Just a suggestion. What will happen between, say, Thursday and Monday?
We'll not really make
have the satisfaction of filing a
It's a holiday.
That's right.
Milord, Tuesday.
Special PMLA bench.
Tuesday, there's a PMLA bench.
Yes.
We'll keep it on Tuesday.
Yes.
And we'll adjust time when all of you are here.
Very well.
Tuesday.
Let them have 3 days to consider and rejoin. That's all.
That's right, Milord.
By
Friday,
first on board, keep it.
Would you not please to
We'll
keep
take it
first on board?
It has to be.
That's
Because
right.
everything well for that.
Very well.
I wish to mention it will take a substantial amount of time because there are allegations and counter allegations.
Ms. Jason, you're always very sharp and to the point. So I'm sure we'll not take too much time.
So
Very well.
Thank you.
Will I'm sorry to, will your lordship like to take up item 62, Malods? That also, Malods, pertains to the Calcutta.
Just wait a minute. We'll just run through the board. Yes, item 1.
Please, Malods.
Please, Lords. Lords, I beg to appear for the petitioner.
This relates to probate proceedings.
Please, Lords. Lords, we had done publication thrice. One at the stage when succession application was filed, no claims were received. And then at the stage when the matter was pending before this honorable court.
But the, matter,
Lords, I see that.
The case has not been settled, right?
I see that, Lords.
So it will have to be heard before the regular bench.
Lords, it's not required, but unfortunately, Religare, which is the depository holding the shares, insisted for it, and it was filed. Once it is filed, Milords, I'm into the trap, Milords. That unless and until
record your statement of no probate is necessary. Yes, and you can just file a suit on the shares. That's much better because why are you seeking a probate when usually it's not a presidency town and you don't require probate?
I appreciate that, Milord.
So we'll record your statement and dispose of the proceeding and leave it open to you to pursue proceedings in accordance with law.
Milords, there is
to protect you.
Milords, there may be an issue because once I have filed the probate, the shares will not be transferred to me, Milords.
Look at it this way. We record
Please,
that according to you, probate is not required.
Please,
since the place where the will was executed is not a presidency town.
Please, Milords.
And therefore, the initiation of probate proceedings was not warranted. We'll record your statement and leave it open to you to pursue remedies in accordance with law. We'll say, learned counsel appearing on behalf of the petitioner submits during the course of the hearing that strictly speaking, the probate proceedings were initiated on a misconception of law, though as a matter of fact, no probate was required to set up the will question. We'll stop in this view of the matter, on the request of the learned counsel, the proceeding shall stand disposed of with the clarification that it will be open to the petitioner to pursue such remedies as are available in law. The petition shall stand disposed of.
But by virtue of the impugned order, probate petition has been dismissed. So today when I
All right.
approach,
Say, in view of the above, since the will was not, since the will was not executed in a precedency time, since admittedly the will was not executed in a precedency time, it needs to be clarified that should the petitioner take recourse to such alternate remedies that are available in law, the observations in the influent order would not stand the way.
so
Item 2.
I beg to appear for the appellant National Insurance Company, New India Insurance Company. It's an appeal. Lordships can hear it on a Wednesday or a Thursday. Yes, because I have prepared a 2-page synopsis. I'll file it. Lordships will hear it.
I'll also file a synopsis. This had gone to Lok Adalat but was not settled, my lord. Therefore, it's come before your
Grateful to you. Obliged.
Lordship,
Who's appearing for the petitioner?
I'm appearing for the petitioner.
Is returnable on. Then right. The petitioner has been implicated in FIR number 78 of 2024, dated 15 February 2024, of offences punishable under sections 3, 5(1) of the UP Prohibition of Unlawful Conversion of Religion Act 2021. Full stop. The petitioner is in custody since 16 February 2024. Charge sheet has been submitted.
Please, Your Lordship.
Charge sheet.
Please, Your Lordship. I have annexed that.
The charge sheet has been submitted after the investigation has been complete. Full stop. By way of an addendum order, we direct that the petitioner be released on bail, subject to such terms and conditions as may be imposed by the trial court in connection with.
Highly obliged, Lord.
No, these are those cases, not where Lord, your lordships will have to.
Our I is on item 35.
Sir, today we were held up in the morning.
It will take some time, Lord, let it be next week or week thereafter.
We can keep it after 2 weeks and we can keep it on a Wednesday.
Lord, that will include 4.35, where I have filed an application. Item 35. Item 35, where I have filed an application. I was mentioning that day.
You are mentioning to us that you will find yourself.
Yes, that order should be varied, Lord. 35.5. And I have made a
Otherwise,
compromise.
we will allow.
Any date, it's for your lordship, but earlier Justice Loco, the 3-judge bench.
I rejected it.
It's all right.
But recall applications were rejected.
35.5.
All right, Mr. Mani.
Anyway, your lordship.
Anyway, your
That
lordship.
they just remind us today we just have to rush through with the board because of the.
Lord, whenever convenient.
Plus ED. Plus 35.5 also.
Yes.
35.
All
Dip.
connected matters.
All connected.
Give a list. We'll spend a lordship's time on it.
Dip.
Yes. Item 5.
Please. ऐसे निकल रहे हैं.
We want Justice Geeta Mittal to examine
Yes,
what can be done for shifting these students. They want, these are 38 students belonging to Zoe tribe.
I wanted to apprise your lordships on 15th of August itself. We had a 2-hour meeting with various vice chancellors, with Central University representatives, State University representatives, the students. We are also in the process of examining whether any of the transfer claims are genuine claims, because now it seems to be
whether any of the
claims for transfer are
genuine.
Because arrangements have been made with regard to there are various conversations which are going on with regard to having practical examinations, having other examinations. The only issue with transfer right now is that there might be some statutory amendments that may be required. So that's in the process of examination. And
so we will simply post it after 2 weeks. Justice Geeta Mittal is looking at it.
Yes, Your Lordship.
And you can just request the judge that when you come back and she has done the exercise of verification, you can just have a tabulated chart for us so that we know each student wise what is the position.
Absolutely. We'll be filing a report, Your Lordship.
It will become a little easier for us instead of then dealing with 38 students without a
definitely
cross reference.
That we'll put the minutes of 15th August also. We'll do everything.
Your Lordship,
There is
I'll just point out.
one more thing.
This has got nothing, this is not a Manipur University matter. That's coming on 27th.
Just 1 second, Santosh. There was another thing I wanted to bring to your lordship's notice, report number 34 and 33. If I can just draw your lordship's attention to report number 34, there are some urgent directions that are required with regard to rehabilitation and construction of the temporary and permanent structures, housing structures. Some money has to be released.
It's coming up on the 27th.
27th.
On the 27th.
Yes, your lordships, because that will have to be addressed.
Right. On this, we will say that Ms. Vivadatta Makhija, Learned Senior Counsel, has apprised the court that the committee chaired by Justice Geeta Mittal is in the process of verifying the individual claims of the 38 students, right?
Yes, your lordships.
Who seek transfer from NIT Manipur to other NITs. So the Justice Geeta Mittal, as stated, has been in discussion.
The committee has.
The committee has been in discussion with authorities at the requisite levels. Full stop. The request of the Learned Senior Counsel.
That's not before this.
Just on, please keep it up to
27, same.
27
Can come up with
This matter is coming on 27th, my lord. The matter before my lords is writ petition 165 of
right.
IA 77182 of 2024.
Putting it on this.
No, madam, may I just point out?
She wants 2 weeks' time.
No. What I'm saying is my application is completely different. In fact, it has got nothing to do with what Vibha is saying, my lord.
What is your application?
My application, my lord. No, my lord. May I just point out?
It's not on board today, by the way.
It is. It is. My IA is on board, my lord.
What
IA
is the report? Tell us what is the
7. My lord, the difficulty which is now faced by students, my lord, I'll just give a broad contours of the
Tell us
position.
what the IA is.
IA is, my lord, what we are looking for is a specific education. I'll tell my lords why.
Education committee for what?
For taking care of the students who are faced with, my lord, there are about 4,000 violence affected students.
What is the
There are about, that's what my application is, that an education committee, because the burden on Justice Geeta Mittal committee is overwhelming, my lord. It's overwhelming. If my lords will look at the 7th August 2024.
But let Justice Geeta Mittal examine this IA.
Lordships, they are asking for another parallel committee to be set.
Only for the purpose of education. May I point out, my lord? There are
It's an open-ended.
Apply committees now. We've got one committee. The learned judge is dealing with it. She's conversant of what has happened so far in Manipur. She has been exceptionally successful in many of her initiatives.
I'm not saying she's not doing a great work, but all I'm saying is the remit. May I submit? Make one submission, my lord. My lord, there can be another committee so that the students can act under Justice Geeta Mittal.
Anything else other than another committee? We don't want to multiply committees.
There are, in fact, the students are almost 1,000 are displaced. There is 1,000 students as of 2023 are
There's a lot of
school students. 4,000 school students are affected. So it will be enormous amount of work is involved, my lord. And many are off the grid. They are not even, nobody is able to even trace them. It is necessary to bring them back.
We are very happy with the Justice Geeta Mittal committee because they are also looking into all education, many skill building and every.
And in fact, prayer.
My prayer is, my lord, my prayer is simple, my lord, is a committee be constituted only for the purpose of education. That's all. That's all, my lord.
That's the only.
That is the prayer, and there is whatever directions my lords want to give to that committee.
Why don't you take instructions on what is to be done about these displaced students? What is the state doing?
Well, in fact, many of these students have already approached the committee, and the committee is looking into various. This is Geeta Mittal committee. In fact,
on the last occasion provided to them. If
they have not given it to us despite our repeated requests. They have not given it. I'm sorry.
Chips made an order that they would be available to them from the
they have been requesting for it.
Elected it or not. Our reports on school education, on transfers, everything.
Not yet given. Several emails have been sent.
So why don't you do this? Make a copy of your reports
We'll do that.
available to him.
We'll do
And you ask Justice Geeta Mittal if she feels that, this is an unmanageable burden.
Yes, sir.
Then we will, unmanageable for her. Imagine for us to deal with 4,000 students. It's impossible for us to spend the time trying to relocate
Yes,
4,000
because
students.
it's not with regard to displaced students we are thinking. This is probably with regard to a complete overhaul of the state system, which I don't think at this point of moment is appropriate for us to go into, Your
Are
Lordship.
they studying today or not?
They're-
And these students are within the state of money?
No, many have dispersed and many have got off the grid because we are not able to establish contact. Even this particular matter, my lord, earlier there were 164 students. Later on, several of them could not even contact us. So, my lord, there is probably a far more elaborate exercise which may have to be conducted by us.
They don't intend to come back to the state?
No, my lord, we do not know. Some of them want to come back to the state.
Committee also who can help them, and the state also is obliged to accommodate them now.
Several, my lord, on instructions I have to state, my lord, as I stated, if my lords will look at the 7th August order, it is an overwhelming portfolio with Justice Geeta. And several communications are unanswered. And I'm not going to fault Justice Geeta Mittal committee at all, because it's a superhuman task which he is undertaking. It is simply a superhuman task which he is undertaking. And I have all the great regard for what he's doing.
Can you just examine this particular?
I'll seek instructions, Malad, but the thing is now, Malad, this application is moved by a student body based in Delhi. We don't know how many people they are in contact with. We don't know whether they have the actual figures. We don't know whether what they are saying is correct or not. Now, and in the current circumstance, this one.
Give a list. We can give a list also. There are absent.
Nodal officer then. At least we have.
Yes, we are. In fact, we went. Several representations have gone to the nodal officer also. As I said, the burden is enormous.
I'll get back to Madras, but as Madras had rightly pointed out, the various nodal officers had been appointed.
All right, you give a copy to the Advocate General. He'll have a look at it and come back to us on the 27th. Then we'll see what their response is.
Please, madam.
Okay.
Please, madam. And the committee reports, if my learned friend could furnish us. I mean, that should be between the bar. Yeah. Yes. Please, madam.
Lordships may make an order for the registry also. If they ask for it, they can freely access it rather than every time reaching out to my office.
One email is good enough.
All the reports which have been submitted by the...
Your Lordships, they don't need to be in sealed cover because they are with regard to all the work that has been done with us. So they can
just email it. I can give them the email ID, Malad, and they can just...
You can request the registry.
Just circulate the copies to them. Other registry will circulate them.
Yes, Your Lordships. Let them approach the registry and ask for copies. Great.
Right.
My lord. My lord, this is the appeal against the NGT's order, my lord. Apart from the natural forest exists, this is also land record shows that the project site is in the jungle. That is means the forest area, my lord. There are other points also. That is, it is a vicinity to the eco-sensitive zone of the Chandaka Wildlife Sanctuary and also biodiversity.
But the committee's report said that this is not a part of any notified forest.
That is the technical.
But is outside the Chandaka Wildlife Sanctuary's eco-sensitive zone.
My lord, that is the technicalities. It is not the notified forest, but it is so record shows that since 1931 it is the forest. And
then finally they have said that a water tank should be limited to 3 acres. That's all.
No, my lord, 10 acres they are.
For situating the water tank for Bhubaneswar.
No,
so that water can be distributed.
No, my lord. There are some other reasons also for them to use this because they will develop that vicinity of the area. That is the main intention. It can be done anywhere, my lord. It is not specific to this place.
You require a height, and if they have identified it.
No, my lord.
And who are we to say?
There are other areas also.
So why should we say you locate it somewhere else? They want to have this area.
Other areas in the vicinity, my lord, which is away from that. Is a sacred.
The entity has applied its mind. We need not entertain it. Thank you. Yes.
I appear for the appellant in item 7.
Two matters. They say that clause 2.2 didn't constitute a guarantee.
Yeah,
And
right.
that's
So
the.
I think that will require consideration, but I'll come to that in a moment. So the first point which I want to make, so there are 2 points prior to, or 3 actually before this point. I'll just state them. There are proceedings between the parties under the SARFACI Act arising from a suit which has been filed by the guarantor. In those suits, so they tried to have an injunction to block the recovery proceedings under SARFACI. That traveled all the way up to this court. So I'll state my first 2 points. My first point is that both in the plaint as well as in the affidavit for a certain leave, because this is, I think, leave under clause 12 in the Madras letters patent, they have expressly said that they are sureties or guarantors. So there's an inter partes. This is not in some third party proceeding. So they have described in a suit filed by them that they are guarantors / surety. That's point 1. Point 2, that matter reached all the way up to this court. And there's a judgment of this court. And and this court's judgment itself in 3 places, which I'm going to show your lordship, they have been described as a surety / guarantor. So my first 2 points are that there is an estoppel by pleading, there is an estoppel by judgment, inter partes between the parties, and you therefore do not even have to go to clause 2.2, which I'm of course going to take you to. The third point I wish to make is it's an admitted position between us that they had funded, in respect of the principal debtor's liability, 38 crores was paid to us. 38 crores was paid to us, which can only be in terms of the guarantee. So they said that no, this was some sort of a, I don't know, goodwill gesture, or there is some expression out of own volition. Sorry?
Why did they pay that 38 crores?
Exactly. So 38 crores is paid to us, and they said it's out of their own volition that they paid this to us. Then I will come to clause 2.2. Now please just go to a few of these items. So first, my lords, please just have a look at PDF page, if your lordships would, 626. I'll go rapidly now that I've stated the points. Please go to 626. Do you have clause 2 there?
Yes.
Now this is part of his affidavit seeking leave. So please see the paragraph 2, the third line. The plaintiff applicant stood guarantee for such financial assistance on certain terms and conditions. Your lordship has that? So this is his own pleading in the Madras High Court. Please go to the next page. Paragraph 3. Next page. Thereupon, the entire outstanding of the third respondent stood discharged. Consequently, the applicant's secondary liability as a guarantor also came to an end. Your lordships have that?
Yes.
The applicant also approached the second respondent for return of the title deeds. And his plaint, your lordship will find, is the next document. And there your lordship may go directly to PDF 634, para 20. Now this is the plaint. That earlier one was the affidavit in support of that leave.
PDF 624.
624. 634, 634.
Which para would that be?
20. At the foot of that page. This is his plaint. May I read it? The plaintiff being a surety, its liability is only accessory and secondary. The provisions of the Contract Act dealing with discharge of the surety are not exhaustive, etc. So he describes himself as a surety. Now this is in his plaint. Now this matter travelled all the way up to this court, and please see now the judgment of this court. Your lordships will just have a look at the 869 PDF is where this court's judgment begins. Please, your lordship has that first page. Now please go to 870, para 2.1. Fifth line, para 2.1, 870. The appellant herein, original plaintiff, stood as guarantor. Your lordship has that line? Yes. Now this is our court's judgment. Now it's, please again go to para 2.2 on PDF 873. This is again inter partes.
Was that an issue, whether they were guarantors?
It's inter partes, my lords. Their whole idea is to first block under SARFACI any further action being taken. It's the same set of transactions. Now, in this, when it comes up to the court, comes up to this court, please see para 2.2, third line or fourth line. Initiated proceedings against the plaintiff appellant herein who stood as guarantor. This is how our court describes the situation. And then please proceed to page 879, last two lines in para 5.4. Therefore, there shall not be any dues to be paid by the appellant herein as guarantor. Your Lordship has that?
In any case, their own pleading was that they were guarantors.
Correct, but yeah, absolutely. Now, the other larger principle for your Lordships to consider is, once our court has held in a judgment inter partes and described them as guarantor, they don't come by way of review, they don't come by way of clarification and say, remove this. Can a subordinate tribunal come to a conclusion contrary? It completely undermines the authority of an inter partes judgment of this court, which I don't believe, apart from the principle of estoppel. Now, please go to that other issue, which is regarding 38 crores of rupees. That your Lordship may just note, it's mentioned and reflected in the impugned judgment itself, that 38 crores of rupees were indeed paid and received by them, were paid by them towards the towards the liability. Now here, can I just see that?
Letter is 466.
Please just go to 4 of the impugned.
PDF 466.
PDF 466.
Sir, Rodney, we have to consider it.
I just want to tell Lordship 2 or 3. My friend, beloved, with respect is wrong on all points. He showed you a judgment of this court.
But no, what about your own pleading?
38 crores.
I'll show. I'll show beloved half a minute each.
Yeah. So, I'll just I've got several other points as well, including clause 2.2.
In any
but
case,
just,
Lord, if 7 has been dismissed against him, he has a right, Lord, of enforcement of SARFACI for the
there's no question of it.
How many recourse will we have? He is already invoked SARFACI proceedings, as he said, which we are facing. In regard to the property, Lord's claim is 700 crores.
His section 7 petition has been dismissed.
Correct.
Yes, it has to be. Now, anyway, let me just proceed. Let me just please proceed.
Lord, of the right of recourse.
Yeah. There's no question, brother. This is out and out a guarantee. I'm going to show that to you. So now please just go to page 1072. Please go to page 1072. 1072. Now just have a look at this. What is this?
This is the reply to him.
Now this is the reply that they have filed in NCLAT. Please see para 49. Your Lordship has that?
Yes.
The contents of paragraph 9.7 are categorically denied. The adjudicating authority rightly held that no details documents have been produced with respect to the to rupees 38 crores, a payment of rupees 38 crores by SRAE to the respondent, and thus it could not be said that the amount has been paid by the respondent to SRAE in his capacity as guarantor surety. The letter dated 30th June 2017, 20th July 2017, addressed by ESL to SRAE, does not stipulate in any manner whatsoever that the respondent made these payments in capacity as guarantor. It is submitted that the respondent made this payment in its capacity as of a promoter entity of ESL on its own volition and not on account of being obligated to do so under contract of surety or guarantee. That's how gullible is institutions are supposed to be. So 38 crores. Now please see this clause 2.2. Please go directly to clause 2.2. Your Lordship will find that at PDF 446.
In the event the borrower is not in a position to comply with the financial covenants provided in the financing document,
yes,
or has breached such financial covenants, the
obliger, that's ECL, will arrange for an infusion of such amount of fund into the borrower such that the borrower is in a position to comply with the above mentioned financial covenant. So this is what is known as a two-step guarantee. Now, my lords, I'll place, if necessary, before your Lordship, there's a leading House of Lords judgment called, my lords, it's Moschi. Now that, I'll tell your Lordship the expression they use. They use the expression that guarantees traditionally were known as see-to-it contracts. So the guarantor was to see to it to be made. That's the expression Lord Diplock uses. See to it. Now, this is exactly nothing but a see-to-it structured guarantee. If there's a default on the part of the borrower, then this party has to see to it, ensure that funds are given to the borrower so that the default is removed.
Such amount of.
But we will issue notice here.
I'm very grateful.
If you actually give me 2 minutes, my friend is taken all the time.
But it requires consideration.
My matter also.
No, I could show the Lordship not.
Your matter, what is that, Dr. Singh?
No, this judgment, we are agreed by the fact
And
that
the
he
second
takes
part-
the amount, second part, he takes the resolution plan, provides for the new SRA to do a reduction. He agrees to the resolution plan. 8 days after I'm gone out, the new SRA, Vedanta comes in, Vedanta comes in. Vedanta then does a capital reduction as per the clause in the plan. And he said that capital reduction should be dealing that the debt is not extinguished, qua guarantor.
What we do is
Notice on both.
their matter.
Both.
Very well, all right.
Matter.
All right. This issue is decided inter partes also, which they've accepted.
Notice should be
And-
on both. I tell you what should buy. Because he is already prosecuting the mortgage issue in Sarfis.
Other matters.
Now, the last part of the judgment, after holding 7 in my favor and rejecting 7, the last part of the judgment says, my lord, that the factum of his debt, my lord, is alive and he can prosecute. So this will be used as, my lord, a stepping stone to go to those proceedings.
If his appeal is alive, then your appeal doesn't survive really.
No, it does, because Vedanta did the capital reduction. Vedanta is a third party.
The earlier Supreme Court judgment.
No, 1 second.
Was- yes,
Lord,
sir.
the impugned judgment is in 2 parts.
Two separate.
One part is dismissing his 7,
7.
for which I am happy, but he is in appeal. The second part of the judgment is
Gives him liberty to take.
to go there and he will use this as a stepping stone to push below his section, his mortgage.
And it creates a limping debt. Well,
There and
debt
limping
qua,
debt.
a limping debt qua me and not qua others.
Tag it.
Yes,
we are
very
all, everybody is here. We are tagging both.
But it may well waste time. Next time there's no
Okay, we
reply,
don't-
etc.
You're both here. There'll be no further pleadings or anything.
I hope
No,
not,
we'll
because something will.
submit a short written note of
No,
argument.
that's it.
Lordship, make it clear
Remember,
that.
I'm happy if your lordship likes, if, I mean, I don't want to sound presumptuous.
only
I
one-
don't mind filing my written submissions here and now and close the case. I'll just submit a note. I made my 3 or 4 points.
No, I
I'll
want to
just
argue.
give you the documents.
I want to argue. He was a, he's a part of the COC. How can he be not?
He knows the plan.
He knows the plan, he endorsed the.
5 pages each and email them to the court master. and so and
One-
so. List on, we'll keep it after 2 weeks for
No
final.
problem.
Yes, correct.
One request which doesn't hurt him. He wants to hurt big others. This judgment should not be used qua other creditors. Because this judgment says, I am not cleaned.
All right. This is
Qua
your-
others, not qua
Because
Mr.
not
Diwan.
now other people
No,
who
not
are
for Mr.
finished and
Diwan.
gone will now come.
Well, there's no
He
interest
said
in
that
this
now
list that he hurt
it
me.
survive.
Qua others.
We'll hear the matter. We'll hear the matter.
Because, beloved, it is our case that the debt does not survive.
This is Tola. This after Tola. You want a declaration that the caste system is unconstitutional.
Yes,
What do you mean the caste system is unconstitutional?
yes, sir. I am petitioner in person.
How is the caste system unconstitutional?
How caste system?
It is unconstitutional. You want a declaration by the court under Article 32.
Because it is violating the fundamental rights, sir. And also, sir, preamble of our constitution investigates the establishment of an equal society based on the trinity
There are provisions
of
of the
equality, liberty, and
Constitution
fraternity.
specifically refer to caste. They specifically refer to socially and educationally backward class of citizens.
Right.
The Constitution, as originally crafted, refers to the scheduled castes and scheduled tribes. So,
Sir, I read the Indira Sani case 340, 341.
another case for our interference. Thank you. Item 10. Excellent. Mr. Agarwal, we'll issue notice here.
Only one problem I must bring to Lordship may issue notice. Only one problem is that Lordship may just note it that to respondent 2, 3, 4 are not parties.
Parties to the.
Yes, Lordship may just note it. Lordship may issue notice. I'll file documents later on. But Lordship may issue notice today. But Lordship may just keep it in mind so that it is not told to me that I didn't point
Mr.
it out.
Gaurav Agarwal, when it's in a council, fairly points out that the second, third, and fourth respondents
Are not parties, but according to us, they'll be covered by Cox
arbitration agreement, would be covered by the judgment of this court in Cox and
and Kings. And two other judgment, but that's all right. This will do.
We'll issue notice and
Great.
hear them on that.
Yes, that's grateful.
Notice referred will happen.
Obliged to much.
May it please, Your Lordship. My Lord, the trial court have dismissed the suit essentially on the ground that it is barred by limitation, my lords. Whereas,
See, the compounding of the construction was on 13th of March 2018.
Yes, my lord.
Writ petition was dismissed on 19th March 2018.
Yes, my lord.
Notice under section 401 of the Municipal Corporation Act only on 8th of February 2021.
My lord.
Which is 3 years, and the limitation is 6 months.
No, my lord, the limitation is not 6 months. And secondly, the High Court has taken note of the fact that illegal construction is a continuous cause of action, but have not decided it, my lord. So, in my respectful submission, it was a mixed question of law and fact.
What is this?
My lord, may kindly see.
In the suit, let's see that.
My lord, in this suit, kindly see, my lord, what I have said. That they were promising that they will remove the illegal construction. My lord, may kindly see this.
Made a decision to compound the violation.
Yes, my lord. This case has traveled.
Can you get relief in your suit without challenging the order compounding the violation?
No, my lord. I bow down to what my lords are saying, but still it will not be within. Still it will not be because my lord may kindly see what 401 prescribes. My lord may kindly see at page 10 the High Court have reproduced section 401 also, my lord.
So contention, Mr. Asani. What's your submission? What's your submission?
My lord, my submission is that 401 subsection 2, which provides for 6 months limitation from the cause of action, will accrue because it's a continuous cause of action. Illegal construction on the road, they have raised the construction, my lord.
Instruction put up, Mr. Counsel.
My lord, this construction has earlier been removed twice pursuant to orders passed by High Court also, my lord.
We'll issue notice here. We'll issue notice here.
My lord.
Returnable in full. Yes.
Please, so at the outset, I must state, my lords, that the cross SLP was filed by Tata Motors, my lords, which my lords are rejected, but it's on a slightly different footing, my lords. But it's my duty to first point it out for my lord's consideration.
This order, the order of the arbitrator,
yes,
the arbitral tribunal, yes, restrain you from recovering the penalty of 78 crores.
Yes.
And their prayer of release of the deducted sum of 49 crores.
Whatever has already been deducted from them, my lords.
They wanted a refund pending the arbitration. That has been rejected. But
for
now
me, they said that I can't recover. They have to furnish bank guarantees. Lords, I can only pitch it on
17 order. Why should we interfere?
Only
it's an interlocutory order of the
I see that, lords. Only at a question of law, my lords, place it, and my lords, I leave it for my lords can consider.
For us to interfere.
Lords, under
arbitral proceeding is pending. It's an award under. It's an order under section 17.
It is, my lords. But the only thing being, my lords, a section 9 was filed earlier, my lords, seeking a similar relief, my lords. That section 9, my lords, comes to be withdrawn in appellate proceeding before the High Court, my lords. They thereafter filed this section 17 before the High Court, the third application. Before the arbitral tribunal, I'm so sorry, my lords. I must also point out there are 2 earlier orders which we did not challenge of the arbitral tribunal, which is noted in the High Court.
The 9th of November 22 and 6th of February 22.
Yes, my lord. Therefore, my lords, I'm stating that, my lords. We didn't challenge that. But the prayer which is sought in the third application was similar to what they had sought in the section 9, which they withdrew. So the issue which we raised before the High Court was, if at all you approach the court in section 9. Very well. I leave it at that. Obliged.
Please, my lords. That's 2 erroneous findings have shut me out, even though concurrent findings in my favor. When the contempt petition.
The contempt was of an order passed by the Company Law Board.
Yes. Now the Company Law Board, the dates are important. Company Law Board's judgment is 27th May 2016. The direction, which is at page 145, is for those preference shares to be transferred to me within 4 weeks. So the cause of action for the contempt will arise on 26th June 2016. In between this is the date 1st June 2016, which is when the new Companies Act, section 465 and 425 come into effect. Therefore, the contempt, when it arises when the new legal regime has come in. This is not taken note of by the court at all. The court presumes that the date for reckoning is 27th May 16, which is the date of the judgment. The date of the judgment can't be the date of the contempt. The date of the contempt will be only after the 4 weeks has arisen and they haven't acted.
And in the meantime, on 1st of June, the new section 465 is taken forward.
Has come into effect. Now, that makes it clear that all proceedings, which I'll just read that section out to your lordships, 465, because something turns on it. This is the repeal provision. The company, etc., shall stand repealed, notwithstanding the, sorry, I'm so sorry. Yes. Now, this is the repeal provision, which says in 2, notwithstanding.
But did CLB have the power, the Company Law Board, to punish for contempt?
No, it did not. Not before that. So it did not. All of those would go to the High Court. But once the new law comes into effect, effectively this order of the Company Law Board would be treated as an order of the NCLT. And the NCLT has the power of contempt, which is provided in 425. So if I can just read 425 to you, power to punish for contempt. The tribunal and the appellate tribunal.
May I just point out one thing? As your lordships rightly pointed out, that the CLB did not have any power to punish.
But in the meantime, the NCLT came into force.
Even if that is so, the moot question is that whether there was any contempt or not. Now, there is a concurrent finding both by the NCLT and the NCLAT that this order could not have been complied by me for the very reason that the entire share capital stood reduced under section 100, which was carried forward till this.
This argument was rejected all the way up to this court
kindly
already.
See page 219 for a moment.
Just there's a second point also.
Kindly see 219, my lords, whether there is contempt or not. Lords, here is an issue where even if section 12 of the Contempt of Court Act is applicable, the monetary relief which has been granted to the other side runs into 5 crores. Now the moot question is that whether in exercise of contempt jurisdiction, this order could have been passed or not. And especially when a finding is rendered, kindly have page 219 for a moment.
CLB directed the transfer of the shares.
That's right. Yes. CLB directed.
There are cases that you didn't transfer the shares in violation.
It's for the reason that there was a reduction in share capital. I have filed an application under section 100 of the erstwhile Companies Act.
Now, in the contempt, NCLT allowed his contempt application and directed you to pay an OTS settlement.
That's right, my lords. And he is not a debt. He's not a creditor, neither a debtor of mine. He's a share purchaser.
How much were you asked to pay by the NCLT?
My lords, more than 5 crores, my lords. Kindly see at page 219.
The original order of the CLB was for the transfer of shares.
Only limited to the transfer. Now, NCLT in contempt jurisdiction gives a finding of fact in my favor recorded at page 219 that this order cannot be complied with because the shares cease to exist because of the reduction capital order by the High Court upheld by this honorable court. So, my lords, in contempt jurisdiction, the limited question is
NCLT, Mr. Shankar Narayan, have told him to pay the monetary equivalent. That's not part of the contempt jurisdiction.
I will agree with that to a limited extent. Just to say this, that what actually took place is that there are 2 sets of preference shares.
You can execute the order by a process known to law, right?
Yes, right. But there are 2 sets.
To execute the order.
I'll just let me just explain for you. There are 2 sets of these preference shares. There's one which was towards loans which had been taken by the company. That is completely separate, which was assigned thereafter from one bank to another, etc. It doesn't concern me. The other is my direct purchase of these shares, which was not executed in my favor. He takes the same objection against the Company Law Board's judgment in my favor goes on appeal to the High Court and says, look, I have no shares to give, so this will become impossible for me to comply with. High Court says nothing doing. Those shares which were all cancelled, those preference shares were cancelled, has nothing to do with these shares that you have to transfer to him. So you will go ahead and transfer it. He comes up in an SLP. I have a copy of the SLP here. Yes, which comes before your lordships and dismissed. After which, when I file the contempt, he takes the same argument before the NCLT. The NCLT perhaps falls into error believing that those shares were also completely cancelled, when in fact, those could not have been cancelled. They were not the subject matter of that at all.
And
which is the
directs him to make an OTS.
Yes, directs him to.
That order on merits anyway was wrong.
Yes. Huh? We also appealed against that order. We had also appealed against that order, but the jurisdiction question arises, and the
question really shades into insignificance, because the order which was passed by the NCLT was palpably erroneous.
It can be remanded for them to reconsider.
But you may still execute the order ultimately.
Do you want to do
that?
Execute the order. You want to do that?
Leaving it open to them to execute the order.
No. Well, could we consider settlement between the two of us? I mean, since we're both here.
That is always open, Manoj. That's always open.
Thank you.
Very well. Just allow me to withdraw, my lords.
Yes, sir.
Withdraw with leave to follow appropriate remedies.
Was to appropriate remedies.
DPU. I'm great.
Yeah, please. ये 13 हो गया.
$14, $15 and $18, your lordship, similar issues were there. So even $18, your lordship, item 18 also.
No, 16 is a section 11, my lords. We had
issue notice.
Yes. There are three matters, my lords. There is 16 and 54.
54.
Yes. There is one more which has been numbered but not listed before your lordships today. That will come in due course.
Yes. 17.
Grateful.
Lord, this is a matter of
sole arbitrator.
Appointment of a sole arbitrator, my lord. The question is concerning the jurisdiction.
You say that you have filed a petition under section 9 of the IBC.
Yes.
And ultimately your 9 is pending, but how do you prevent him from appointing an arbitrator?
My lord, the question is, my lord, that this is clearly a moonlight defense, an afterthought by the respondent. No, my lord, the impact is on the NCLT proceedings itself, my lord.
For the arbitral tribunal to decide whether the defense is moonshine or otherwise.
No, the reason is, my lord, that this honorable court has held that even while considering the jurisdiction under section 8 of the Arbitration Act, where it is similar to section 11 concerning the referral jurisdiction, the court must consider whether these arguments are moonshine, whether they are an afterthought, whether they are intended simply to scuttle the entire IBC process. Here, the factually.
Section 9 will be heard on its own merits.
No, my lord, the adjudicating authority, in fact, is being impacted by such defenses being taken.
Leave it at that. Thank you.
My lord, may kindly consider giving a clarification to the adjudicating authority that these arbitration proceedings should not impact the
you can argue the
IBC proceedings. Yes. Lordship may kindly consider.
Thank you.
Much obliged.
18 is a tax matter. 19?
Please, my lord. My lord, perhaps the filing of this writ petition has, my lord, expedited the action on the part of RBI. My lord, 4 days back, they have brought a new master guideline. So, my lord, I'll withdraw.
You withdraw it, Mr. Avasti?
Yes, my lord. They have brought in a new master guideline on 16th of August, my lord.
Item 20.
20, my lord.
You have to tag it with Harjinder Kumar.
Kindly issue notice. We are the people who were actually called for the interview and not selected.
We'll issue notice and tag with that diary number 29978.
That actually had to come up on 26th of July. It hasn't come up. Can your lordship give some date?
We'll issue notice. There must be already a date.
6th September, it's showing. Tentatively showing 6th September.
We'll hold it down to 6th.
Yes, grateful. And then give me Dasti as well. High Court, I'll take Dasti. Grateful.
Is also relating to the same selection.
She's the topper actually.
The candidate. And there was the
oh yes, that's right. This is also noticed.
She's actually the topper. Yes. So let this. Yes. Great.
21.
Please, this is connected to item 57. All
57 and 57.1 million.
With Sada Metals?
Please, my lords.
Yes, my lord, yes, yes.
Is at page 282.
7196 of 24?
Please, my lords.
All right.
My lords, the notice was also issued in the stay application. I'm also praying for this. Grateful.
21 and 57.
57.
Please, my lords.
22?
My lords,
Mother of There's not a case of passive euthanasia.
Yes.
He's not on any life support. You want an active end to the life. It's a very hard case we see, but it's not a case of passive euthanasia. Passive is when someone is on life support and you withdraw the life support. There is no life
he has a life support.
What life support?
Insubstantial collection is the suction catheter, feeding tubes. Without any tube, he cannot survive a minute.
That's not life
And
support.
his mother seeking passive euthanasia because she is not in position to taking care of anymore.
No, but this is not passive euthanasia.
Lordship,
This is not passive euthanasia.
and in the High Court, High Court did not.
Why now?
In Ghaziabad, at home. At home. And without external aid, he cannot survive. But mother and father cannot.
No, it's not like a ventilator.
Lordship, they have no means to provide these kind of machines. These kind of machines,
Right.
and he is suffering from last 11 years, vegetative state, and
You can't say it's a case of passive euthanasia. What you are requiring is active euthanasia, which our law has not.
Lordship, we are only demanding the medical board who examine the condition of the petitioner.
But there's no life support.
Lordship, I raised this substantial question in my petition and page number 4, whether the definition of life support restricted only machines or including suction catheter, feeding tubes, and
So tell
urine
us,
pipes.
how will any medical authority put an end to life?
Uh,
Merely pulling out the Riles tube will not, he will starve to death.
Yes.
If you pull out the Riles tube, he'll starve to death in 3 weeks, 2 weeks, whatever.
Lordship, but
That's not a case of passive euthanasia. He's today not on, say, a ventilator. Say somebody who's on ventilator, end stage cancer. Somebody's on ventilator, you say, all right, but family says we don't want a ventilator. Here is a case where the person is on a Riles tube. A Riles tube is a feeding tube. It's not life support. It is necessary to sustain life in the sense that his nutrition is given to him from the tube. But just withdrawing the tube will not, nobody will do that. You will have to inject something to kill him, to stop the heart. That is not passive euthanasia.
But at the same time, I requested to this honorable court, kindly direct the AIMS or any other government hospital to admit the patient, QA the petitioner, and provide best treatment, because I am not able to give them best treatment. Because mother and father become advanced and 64, 65, 55 years of age, and he is also 32 now. And वो भी बड़ा हो रहा है, उसकी भी age बढ़ रही है, तो day by day.
Examined the last. Who examined him the last?
AIMS and 2 departments, Lordship. I'm showing the document.
Was that certificate?
Page number 58. Yes, 100% diffuse axonal injury with vegetative state, 100% paralysis. PDF 58. That's a certificate issued by the medical superintendent, Janakpuri Super Specialty Hospital, as well as the Dr. Ram Manohar Lohia Hospital on the very next page. Page number 59 of PDF. And first one was in 2014 and second one is 2016. Locomotor disability, whole body. He cannot move his hand. Paper.
Not there.
This copy is sent by the registry. What master, sir? Sure that.
By its influent order dated 2 July 2024, dismissed a petition under Article 226, by which the petitioner, by which the petitioner sought the constitution of a medical board to consider whether his son can be permitted to undergo passive euthanasia. Good stop. Harish Rana is the father, right?
Harish Rana is the petitioner, Ashok Rana is the father.
The petition was filed in the name of?
Yeah, petitioner filed on the name of the petitioner, but filed by his mother.
A petition under Article 226 of the Constitution was instituted before the High Court of Delhi by the parents, into brackets, Nirmala Devi,
yes,
and Ashok Rana, in the name of their son Harish Rana, seeking that he may be examined by a medical board to consider a case for passive euthanasia, to consider administration of passive euthanasia. Harish Rana is a 30-year-old who suffered head injuries after sustaining a fall from the 4th floor when he was a student. He is bedridden since 2013 and is stated to be in a permanently vegetative state, suffering from quadriplegia with 100% disability. The High Court dismissed the petition, holding that active euthanasia is impermissible in view of the judgment of this court in Common Cause, Purana, 2018 5 SCC 1. In the present case, the High Court was of the considered opinion that Harish Rana was not being kept alive, into single inverted commas, mechanically, and was able to sustain himself without life support or external aid. Next. Prima facie, we are in agreement with the view of the High Court that the case would not fall within the ambit of passive euthanasia, since Harish Rana does not appear to be on life support, which can be withdrawn. At the same time, this court is not has to be mindful of at the same time, the submission before the court is that the parents are now aged
50. Father is 62 and mother is 55.
62 and 55 years respectively, and are not in a position to care for their only son, who is in a vegetative state for the last 13 years.
Yes.
In order to examine whether a humanitarian solution other than passive euthanasia, can be found, more particularly by exploring whether any other facility can be located where the needs of Harish can be taken care of. We issue notice to the Union of India. Liberty to serve the standing counsel in addition. We request Ms. Aishwarya Bhati, then ASG, to assist this court. List on Kardo. We'll see if we can be placed somewhere else.
Lordship,
very hard case.
Lordship, they sold their house to take caring of his son. In Delhi, and they are living in Ghaziabad.
Gone strictly on merits, there's nothing in the matter, but we'll see if something else can be explored.
Yes. Obliged, Minister.
May it please your Lordship. My lords, I seek the tagging of this matter with writ petition civil 214 of 2024, my lords.
The writ petition 214 of 2020.
I
Yes.
seek the tag. Obliged.
Send that.
Please, Your Honor. Please. Please, my lords. My lords,
Interlocutory order matters listed now on the 2nd of September before the NCLAT.
please, my lords.
Who is appearing for the petitioner?
I appear for the petition.
Why should we interfere at this stage? They have said issue notice.
Yes, my lord.
The CIRP against the personal guarantee may continue, but no resolution plan will be
Yes,
finalized.
yes, my lords. My lords, before the NCLAT, I had only raised two objections: limitation, my lords, and the notice was not served upon me. My lord, these were the only two objections.
That will be considered now on the 2nd of September.
Yes, my lord. My lord, the court, despite saying that yes, these both the points need scrutiny, my lords, the stay has only been given in a partial way, my lords, and complete stay has not been given. So tomorrow, my lords, if I don't give the plan, my lords, they may continue to go for insolvency against me, my lord.
Now it's coming up on the 2nd of September, is not. You argue everything before the NCLAT.
My lords, may kindly just say one thing, that on 2nd September, this application will be decided then.
It just says that since the appeal arises from an interlocutory order dated 16 July 2024 of the NCLAT. Good stop. The proceedings having been posted for the for hearing on 2 September 2024, we are not exercising jurisdiction at this stage. Of all the questions of law which have been raised by the appellant will, needless to add, be considered by the NCLAT. The proceedings are taken up on 3 September 2024.
Lord, my
appeal is disposed of.
Lord, my application may be
Yes, we have said that will be taken up.
Grateful, Lord.
Grateful, Lord.
Who is appearing? Can't be done. Nothing can be done. You see, you registered yourself as a general category candidate.
I 100% I done the mistake.
After the results are declared, you say, no, now I am an OBC candidate, MBC candidate.
I am not claiming anything now.
Then why are you here if you're not claiming anything?
I am only claiming that now I got in for the private college. I am eligibility. I have the eligibility to.
Now results have been declared. Now, once you fill up a form and say, I belong to the general category, you can't turn around and say, now I'm most backward category.
And done the only by mistake there.
And by the way, your certificate I noticed was of 15 June 2024.
That is, I am 100% admitted. Now I am unable to join in even the payment quota in other colleges itself. That is why I am come to before the RC. Even I got the admission. I am also, no, I am not disturbing for any admission in anything. I am getting even, I am unable to get the admission in the private college itself. I am already secured for a.
That's all right, but you filled up a wrong category. What do we do now? Next year you can do a.
Error, Millard. This is not a voluntary. I am by then the mistake, by mistake at that time.
You know, you have to also understand that in a large exam, we can't now intervene for students who make mistakes in filling up their form.
Only one thing, this is a general category. At that time, I am unable to understand that I am a young boy, that I am unable to understand.
You don't know that you belong to an MBC.
But no, that
the whole world knows that they belong to an OBC or an MBC. How can you say, I don't know that I belong to an MBC?
But that is by mistake only I am done that. It is not a.
Not
even
Thank you.
Unable to get it for even private.
Thank you. Dismissed. Yeah. That's my point.
Lordships
Should be on the basis of the guidelines on the date of the conviction or the present guideline, whichever is liberal.
I'm so grateful.
In fact, if you see our judgment, have you seen that?
Lordship Zafar, I've
the
put it.
UP case.
Yes,
We have expressly put that in.
Lordship 19.2, paragraph 19.2.
We'll issue notice and.
I'm so grateful. Lordship, I'm in.
And he has been recommended by everybody. Of course, the crime was very bad.
Very heinous, my lords.
He burnt those.
Very heinous crime, my lords.
Very heinous crime, but now he's undergone 24 years.
24 years, 6 months.
We'll issue notice.
My lords, may I request lordships to consider his bail?
We'll keep it after 2 weeks. Serve this from where? Odisha?
Yes, ma'am.
Serve the standing council and issue notice. Serve the standing council for the state of Odisha and we'll list it on a particular day. Only a little clarification that it will be considered on the basis of the guidelines, on the basis of the date of conviction or the present guidelines, whichever is more liberal.
Yes, my lord. I have, my lord, set up the case laws where lordships have taken a view that more liberal policy will be. I'm so grateful.
Make it returnable. 28.
I'm so grateful.
May it please, my lords. My lords, my lords, the only question in this matter before my lords, which the special court finds in our favor, is whether under section 173(8) of the Code of Criminal Procedure, can the magistrate/court order further investigation? This is the only question. Your lordships, through Justice Nariman's decision in Vinubai, have categorically said that yes, the court can order further investigation.
Two is the complainant in the POXO case.
Yes.
And the special court by its order had directed a further investigation to receive certified copies of the foreign investigation.
Yes, authenticated copies of the counselor's report and the complaint, which is filed in Britain. Yes, my lords, in your lordships have said, and I've got the judgment.
You can't claim a right to further investigation.
No.
What you want now are copies of the UK police station papers.
May I?
Barnet Police.
No, my lords, we are just saying that authenticated copies of the documents, we file an application, even in Vinubai. The
It's now at the stage of framing charges. Cognizance
My
should be
lords,
taken.
charge sheet has been filed. And at this point, even in Vinubai, the application may have been filed by the accused, but it is a decision for the court to make. Once, my lords, may I say this? I appreciate the facts on the merits. I'm not on that at all. But should your lordships take away this power of 173(8) vis-a-vis further investigation?
On facts, not a case for our interest.
But my lords, I am here in this petition only on law. The special court is
We have to
only.
also look at the facts, right? It's not a case for invoking one.
May I only take you to the special court's judgment, 2 pages. May I just take you to this?
Case for our interest. Thank you.
But my lords, may I just put one argument forward? If the
Just
doesn't have the
quickly
power,
the proceedings, yes.
but your lordships, even under the Evidence Act.
Dismissed, yes.
Grateful.
Though I would like to place a lot of information, but could you hold it on for some more time? I'll come back with the.
Take some more.
Yes. One
Same.
Very good.
This perhaps may have come by inadvertence because your lordship's direction was for a non-miscellaneous day. Today was actually non-miscellaneous, but then it became a miscellaneous.
Keep it.
My lord, there is some urgency in the matter.
We'll not give a long date, but we'll keep it on.
No, my lord,
Today we have no time to now. We have
Yes.
a board of 30 more matters today.
No problem.
My lord, one thing is the urgency. I'm appearing for the National Stock Exchange. Every day counts because what has happened is one broker who went rogue, he had pledged securities to the banks. Now the securities which are sold of people who have no debit account. So innocent shareholders whose accounts were in the demat account, they're completely sold. So now what's happened is in 2020.
We take it up after 2
Yes.
Today we don't want
My
to,
friend.
we just want to run through the board. We were held up in the morning session today by the Calcutta rape.
2 weeks.
31 also, Lordship. May not miss-
31 also will.
Oh, okay, Tuesday.
31,
Let's
you
see
know,
them
Mr.
institute.
Tata, it's an ambitious petition which you have filed.
No,
It will be a pleasure to hear you in it because it's a very neat constitutional issue, but there's
No, apart from constitutional issue.
exemption.
No, apart from constitutional issue, Lordship, I have it on next Tuesday. Apart from constitutional issue secondary, what I'm submitting is if I'm getting a waiver, you can't tax a waiver because if the Maharashtra government writes off stamp, it can't be a deemed income.
That's a matter of fiscal policy.
No, it can't be, my lord, because the constitution bench says if an item can't be treated as income, it can't be taxed under entry 82. Namita Zaveri. Suppose I get a waiver of Provident Fund for 10 years. The waiver can't be taxed. And what's happening is Maharashtra government is giving 1,000 crores of subsidy 50 years. Yeah. That's the point.
Who's appearing for the Union of India?
No, Mr. Mr. Venkatraman said he's going to be in NCLAT, so I don't want to take an order behind his back.
Tuesday we'll take it up.
Or I've just requested
Just
him,
inform him.
because I'm not asking for any stay or anything like that, because the project will go on till 2045.
Mr. Bharti?
May it please,
Maybe on Tuesday, no? Or if Lordship wants to file a counter, I don't know, whatever.
Mr. Bharti, are you filing a counter or anything here?
My lords, I am on behalf of Mr. Venkatraman here today. My lords, may have it on Tuesday. The ASG will appear before your lordships.
So it's more than constitution is this subsidies, my lord. So 30 can be able.
Very grateful to you.
One request for the 30, my friends, Lordship can give us. No, the 30, sorry, my friend.
Next Tuesday is miscellaneous because Monday is a holiday, so we'll keep it Tuesday week then.
This matter? No, this which one, Serum?
Yes.
Can it be because I'm coming physically on next Tuesday? So it's admission, notice has not been issued.
Alright, Tuesday kora to chale. Tuesday.
No, unless the Lordship is issuing notice, then.
Tuesday we'll take it up. You're
Not
right.
even this, that National Stock Exchange, some date can be given because.
He will, he will give right away after 2
After 2 weeks, my lord?
Yes.
Very well, great.
Please, my lord, I appear for the petitioner, my lord. Lordships had suggested and negotiations had taken place. My lord, some suggestions and some mediations have come out.
Ms. Bhatti told us last time
Yes,
that
but they
efforts
want
are
to
being
settle
made
the
to
matter.
resolve
Madam.
disputes.
That's what they
Yes,
want to settle the matter. Could your lordships give me 4 more weeks, Milord, because it's in the final stages of negotiations.
Lordship may have, then you lordship may say so. For settlement, lordship may have posted 9 September.
All right, 9 September.
9 September. For settlement, Milord.
For settlement.
For settlement, because otherwise I don't want to go back again the settlement.
My friend had also said that he will not.
No, I have already given a letter. I have already given a letter of interest.
Regarding the contempt.
Next, 33.
I've already said that.
Eight.
There is no. That
33, my lord, I am
Obliged.
seeking pass over that Solicitor General is appearing in this matter.
Milord, I am
Let
appearing
in other
for the
court, my lord.
respondent.
34.
The lordships are passing over, Milord.
Passing it over, yes.
My lords, in 34, I have to file my Wakalatama. I'm appearing for the backward class commissions in this.
All right, take it some other time.
I seek one week.
Yeah, it has been mentioned already. 6. 35. Next, follow up.
Lords, I think these were with those coal matters, item 4. Mr. Rodgi had mentioned, these are connected to those.
Not 35.
35.5, 35.6.
36.
But I appear for the caveat.
Good move.
Yes.
36?
Yes.
Yeah. Now, here, what has happened is that there was an error on our part.
You filed an appeal and you filed a writ.
But our counsel should have mentioned it to the bench. We should have mentioned it at the opening.
And I am
part.
withdrawing the writ and P is
No,
therefore
that
allowed.
I have already disclosed it in my memo of appeal. I have actually withdrawn my writ. That's all complete. But I think our counsel should have probably mentioned it in the opening. Now, the moment it was mentioned in the reply, we said we gave an undertaking or we indicated that we are going to withdraw our writ petition. We've not moved the writ now. This is a
Mr.
bit.
Reddy, what we'll do is
This is too
they have
harsh.
withdrawn the writ petition.
Yeah.
So we'll restore the appeal and ask the NCLAT to hear the appeal.
Only one fact, and I leave it to your lordships. It's your lordship's discretion. The withdrawal happened one day after, my lord, the NCLAT dismissed their appeal on the ground of not bringing it to the NCLAT's notice. So the memo was filed post-hearing and the withdrawal happened next day. They were trying to rectify the damage next day. I just need to bring this to your lordship's notice.
No, that is
because
correct.
they had not brought it to NCLAT's notice
But now
fairly.
they've withdrawn the writ. Let the appeal be heard on merits now. The National Company Law Tribunal admitted a company petition under Section 9 of the Arbitration of the Insolvency and Bankruptcy Code 2016 by an order dated 4 June 2024.
24, correct.
Stop.
Writ was filed on 12th June.
The appellant instituted a writ petition being WP number 15859 of 2024 before the
Telangana High Court.
before the High Court for the state of Telangana on
12th June 2024.
on 12th June 2024.
Statutory appeal was 15 June.
Is filed before the NCLAT on 15
June 2024.
When the appeal came up for hearing before the NCLAT, it was dismissed by the impugned order dated 24 June 2024 on the ground that the appellant could not be permitted to take resort to 2 simultaneous remedies, and the fact that a writ petition had been filed was not placed before the appellate tribunal.
Not mentioned. It's actually in my appeal.
It was not mentioned before the appellate tribunal at the very threshold of the submissions. Good stop. We have heard Mr. Shyam Diwan, learned senior counsel, appearing on behalf of the appellant, and Mr. S. Niranjan Reddy, learned senior counsel for the respondent. It is not in dispute that the appellant had disclosed in the course of the in the memo of appeal,
yes,
that a writ petition had been instituted before the High Court of Madras.
Yeah, Telangana.
Or before the High Court of Telangana So be that as may, we find some merit in the observation of the NCLAT that the fact that a writ petition had been filed should have also been mentioned upfront before the appellate tribunal when the appeal was taken up. However, however, it is common ground that the writ petition which was instituted before the Madras High Court, before the Telangana High Court, High Court of Telangana, was withdrawn on
25th June.
On 25 June 2024. We'll stop. Mr. S. Niranjan Reddy, Learned Senior Counsel, correctly submits that the withdrawal of the writ petition was a day after the impugned order was passed by the NCLAT. We'll stop. However, having regard to the interests of justice, we have the view that it would be unduly harsh to penalize the appellant on the ground that a writ petition had been filed in addition to the statutory appeal when, as a matter of fact, the writ petition has now been withdrawn from the High Court. In this way of the matter, we allow the appeal and set aside the impugned order of the NCLAT Chennai dated 24 June 2024 and restore company appeal number.
It's a little complicated. ATCH
210 of 2024.
210 of
Add to the file of the NCLAT for disposal afresh. So, however, it is clarified that this court has not expressed any opinion on the merits of the rival contentions which are kept open. Full stop. The appeal is accordingly disposed of in the above terms. Yes.
Well, may I just request that observation, last line of the impugned order, misconduct on the part of counsel, that may not be, I mean, I'm not saying it was, we should have done it, but it was a bit harsh, Manoj.
What will happen? Nothing will. Sorry.
All right.
Your Lordship, I appear for respondent number 1, the IRP, who has been removed and a new IRP has been appointed. So he's no more a necessary party.
Yeah, we have restored the appeal. Yes.
Please, Your Lordship, deeply.
Well, then item number 37, Senior Advocate Mr. Pinaki Mishra is leading us in the matter. Milords, may kindly give us some passover, Milords. He's on his legs in court 5.
We keep it, otherwise, if you want it, we can take it up.
It may be kept on Tuesday.
Yeah.
So here the report has come, Your Lordship.
Report has come.
Yeah. So anyway.
Tuesday next?
Tuesday.
In item 22 today, it's a very hard case. There are two parents of a 30-year-old boy, 30-year-old man. He suffered a fall from the 4th floor 13 years ago and is lying in a vegetative state with the parents at Ghaziabad. Father is about 64 and mother is 55. They moved the Delhi High Court seeking passive euthanasia and the constitution of a medical board for passive euthanasia. High Court correctly dismissed the petition, saying that our law doesn't permit active passive euthanasia, but passive euthanasia. Passive means you can withdraw ventilator support or life support. He's not on life support. He's being administered all nutrition through the Ryle's tube. So we said that the High Court is right, but we are really moved by the plight of the parents because they've been looking after that boy for the last 13 years. He's absolutely in a vegetative state. We put it to the counsel that, look, to put an end to his life, you have to inject a substance, which is not permissible in our law. But the reason we have mentioned that, we requested you to assist whether some alternate can be explored, maybe some institution where that boy can be placed. He has bed sores, mother is aging, father is aging. It's a pathetic waste. They cannot afford the cost of care. So is there some possibility of, exploring some place where he can be lodged in some institutional framework where parents, I imagine the parents are now into a situation where they want the life to be put an end to, but at least So you can just look at it, that's serial number 22. If you want a copy, you can ask your junior to
I will
take it
take it,
from
my
the
lords.
courtmaster.
I will take it, my lords.
I think we've kept it on a books, ma'am, for date bata do, huh?
I will, my lords, I will take the details. And I will come back to assist your lordships, my lords.
Yes, you can.
I'll take it, I'll take
Well, you are. Item 38, no?
May it please, Your Lordship. I beg to appear for the appellants, Manoj. This is a statutory appeal.
I know we said it to you before, but delay of 219 days, Mr. Ramadi.
But Manoj, this is a statute.
Yeah.
Item
Order of 26th of September 2023. What is your client? What is left?
No, my lords, there's no delay in
There's
this.
no
my
delay.
No, but why does no delay here?
No delay in this.
All right.
Your Lordship has item 38. So this is a
Now,
statute.
the appellant was released from service on 1 July 21, right?
No, Manoj.
I think my lords have a different brief. There is no delay in this, and this is a
Yes.
set of 13 petitioners. There were 53 applicants before entry.
Manoj, these are those 53 persons, Manoj, who've been refused permanent commission.
Sorry, this was actually tagged on 12th of August with Khushbu Gupta.
That's right.
Khushbu Gupta, there is a delay of 290 days.
Yeah.
290
In this case, Manoj, there is no delay.
Right,
That is Puja Pal, there is no delay.
right. Now,
So
what is
this, Manoj, essentially concerns, Manoj, 53 lady officers who have been denied permanent commission. They originally were from the same batch of some of the matters that your lordships dealt with earlier. These persons were sent to the Armed Forces Tribunal. And then thereafter, Manoj, their case was adjudicated by the Armed Forces Tribunal. And ultimately, the view taken is that this order, Manoj, of the army denying permanent commission to 53 persons has been upheld. That's the sum and substance of the impugned order. Now, essentially, Manoj, there are 2 or 3 points which I want to urge in support of my appeal, Manoj, for your lordship's consideration. And one of the main grounds, Manoj, for rejection of permanent commission by the Armed Forces Tribunal is that there weren't adequate vacancies. So many of them, Manoj, actually make the cut. But the Armed Forces Tribunal, Manoj, calculated the vacancies at 120 for this particular batch. And my first submission before your lordship is going to be, Manoj, that calculation of that vacancies of 120 in terms of the army policy of 2010 and the formula which is relied upon is itself erroneous, because even if you apply that formula to this particular batch, the number of vacancies come to approximately 170. So therefore, my lords, almost 172 or 173. So there were adequate vacancies to absorb all these 53. So that's my first submission. My second submission before your lordships is this, my lords, that as per the judgment in Nitisha, your lordships had laid down with respect to this particular batch that the marking of ACRs, etc. was casual. It was not properly considered. The tribunal, my lords, appears to have taken a view in variation, my lords, of your lordship's judgment, where they say that no, notwithstanding the fact that at that point of time, though permanent commission was not in horizon, taking a holistic view of the appraisals, etc., that were made, and the fact that most persons were actually recommended, it appears that that is not so. So in my respectful submission, there would be a disparity between
your batch, how many women officers were considered for PC?
So this batch, my lords, concerns 53.
Who have been denied?
Who have been denied.
How many were granted in that same batch?
In that same batch, my lords, the figures are there at page, I think, 263.
All right. So anyway, we'll come back to that in a minute. So
Yeah.
The second point is marking of ACRs was casual, which is what we held in Nitisha. And then?
That's correct, my lords. The third aspect is, my lords, that insofar as the grant of pension is concerned, your lordship recollects the judgment in Babita Punya, where your lordship said, allow them to complete those many years in order to get pension, that period of So that the tribunal has said that that is beyond my domain
There's Article 140.
because that was an Article 142 direction.
Now, how many years did these people serve?
These about 14 years.
And in Babita Punya?
In Babita Punya also, my lords, your lordships recollect, Babita Punya subsequently, even some persons who had completed 14 years, your lordships did pass that order saying give them pension. So these are the three issues which will arise in this case. The third issue, my lords, the tribunal also fairly says that this is not within my domain. That would be only within the domain of the Supreme Court. So therefore, I don't go into it. So these are broadly the three questions which arise.
The first point, that the vacancies were not properly calculated.
Yes. Now may I show that, Manoj? May I demonstrate that from the impugned order itself? If your lordship sees the calculation of vacancies in the impugned order, your lordship will find at page 125. I'll have to take your lordship through three documents to demonstrate why it is wrong. (125), if your lordship sees paragraph 120. This PDF 168. Does your lordship have it? Para 120, Manoj. At PDF page 168, paragraph 120. Manoj. Does your lordship have the file
120
of Pooja Pal, Manoj?
Yes, yes.
Yes.
Yes, we got it.
Yeah. The parameters, would your lordship see that? The parameters for grant of PC are laid down in the policy letter dated 15/1/1991. The policy stipulates that a maximum of 250 SSCOs will be granted PC per year. Since SSCOs are commissioned in two distinct batches in a year, the 250 vacancies are to be apportioned to the two batches proportionately based on the batch strength. It is to be seen from the records that the vacancies have been proportionately worked out on the basis of batch strength and with each batch further proportionately worked out for non-tech and JAG batches. The details of vacancies worked out for December 2020, number 5 SB, as seen from the departmental files produced before us, as per the illustration explained in file noting 22/1/1991 reproduced at paragraph 93. The vacancy calculation is given below. Now, this is the error. Just see, my lords, under A, I am compared with September 2010 batch. And that is the figure which is used. My submission is that as per the policy, I had to be compared with March 2010 and prior thereto, where the vacancies were much larger, because...
Why did they compare you with the September 2010 batch?
That's the error, because just see the policy. That's how they say that the vacancies will be calculated as per this policy. So let me take your lordship through the policy. Your lordship may just hold page 126 and then compare it with their policy letter, which your lordship will be pleased to get at 238. PDF page. PDF page 282. And then there is a formula overleaf. So I am saying calculate as per the formula.
In January 91?
Lordship, please. Justice Padiwala has that?
Got it.
Yes. I am directed to refer to the ministry number such and such, dated 8/6, corrigendum number such and such, on the above subject, and to say, grant of permanent commission to short service commissioned officers, government, under the above UO notes or corrigendum, will hence be regulated as under a minimum of 250 SSCOs will be granted permanent commission per year. Number of vacancies for batches within the year will be allotted in proportion to the intersay strength. Now, my lords, how is this to be calculated? Your lordship will get it over the page. Please see the next page, PDF 283. And say modalities for implementation of government order EBIT will be as under: A, grant of PRC to the total number of SSCOs in a batch will be based on intersay batch strengths in 1 calendar year. Now, please see the formula below. So the above is illustrated with the following example. A, let one course intake be 240. Let two course intake be 80. Total intake for the year is 320. Numbers to be selected from the first course is 240 multiplied by 250 divided by 320.
What is 250?
250 is what your lordship saw on the previous page. The number, the maximum number.
Right.
Yes. Now, please don't interrupt me if you don't need. So, course 1, 240, 80, and the formula is 240 into 250 divided by 3.
Basically, 250 will be taken as a proportion of 320.
Yes.
320 being the total number.
Yes.
And then that will be the multiplicand for 240.
That's right. So,
and then for the second, it will be 80.
Yes, because it's just on an assumption that the first course has 240 and the second course has 80. These are on assumed figures. Right. Now, kindly apply this to what we have.
Yes.
So, in Nitisha's case, it is common ground.
Now, there were 2 batches for your year also.
Yes. So, the batch applicable for me would be the first batch. That's March 2010, not September.
How many vacancies were there? How many would be intake? What would be the intake for March 2010?
March 10, that's what I'm saying. So, you have to compare me, we have to compare me with March 2010.
Right.
So, in March 2010, the total intake was 92. And September 2010, the total intake was 197, which your lordship will get at page 9.
So 92 plus 197 is 279.
Is 289.
299.
Yes.
289.
289. So you multiply 92 into 250 and divide it by 289.
Okay.
You will come to 80.
Right. And then?
And second batch, you multiply 197 into 250, divide it to 289, you will get 170.
170.
Yes. So therefore, the mistake that you made in the calculation of vacancies is, if you're and I can get these figures are something which they've admitted in.
So how many vacancies did they take?
They took 120.
For both the batches?
Yes.
So
no, for only one batch. So instead of 170, they should have taken 170, my lords.
The second batch, September 2010.
September. So they should have taken, my lords, 170.
And they took 120.
They've taken 120.
So 50 more vacancies.
So that's my first point. That's my first submission. So if there were 50, even, my lords, the tribunal finds that most of these persons were otherwise qualified.
What did the tribunal say to this?
Unfortunately, my lords, the tribunal merely gives this calculation, which your lordships have seen at page 125, which is incorrect. Because the submission made before the tribunal was that don't restrict it to a vacancy of 250 that has been breached earlier. So give them more vacancies. I'm for a moment, because the policy of 19...
Hold it down to 250. But you are saying
our submission...
50 vacancies.
That's right.
And then the total vacancies were, the total intake was 289.
That's right.
So you distribute the 289 between 92 and 197.
And you're coming to 170. So therefore you get 50 more. 172, 173, you get 50. And the broader submission is that the policy of 1990 is outdated. You couldn't have restricted it to 250 only. You should have increased it because over a period of time, a lot of water has flown. But that's the other submission. But the state submission here is that the calculation of vacancies at 125 appears to be incorrect, prima facie. And I can show that the figures that I relied upon.
What is their answer to that, Ms. Bhatti?
My lords, the answer is that every year has two batches. One is commissioned in March and second is commissioned around September. So my lords, two batches will come up for consideration together. How they are considered is in the 10th year they are considered.
But
Because
there's a bifurcation, right? There's a bifurcation.
yes, and my lords, the policy determines in what manner it is to be calculated. But if your lordships will see para 120 again, kindly see how the tribunal deals with it.
The total the total intake was 289.
That's right.
So that would be the denominator.
1 second. 120.
Yes, my lords.
And
But what
the numerator would be 92 multiplied by 250. Right?
my lords, the error in the argument in our respectful submission of the petitioner is they are wanting the calendar year March 2020 batch and September 2020 batch to be put together.
And
Whereas the mandate of the policy is that in the 10th year you come up for consideration. So whichever two batches, it may not necessarily be a calendar year, two batches completing 10 years together. The SB5 is being conducted, two batches are to be considered together, and this is the same pattern we have been following. It's two batches that are considered together, and the calculation is on the
Two batches.
which two batches? The calculation is on the basis of which two?
Which were the two batches?
In here, this is, if your lordships will have the page 127 again, the table gives it, my lords, the table on the following page, para 121. 120 my colleague placed for your lordships' kind consideration. Kindly have page para 121, my lords. If your lordships will see this table.
Page 164.
So the first two batches, that is September 2010 and March 2011. These two batches are considered together for permanent commission by the SB5.
You didn't take March 10 and September 10.
March 10 was already considered in the earlier round. So
September 10 and March,
yes,
March 11.
So it's in the 10th year of their service, commission services when they come up for consideration.
So it's actually 54. We are concerned with SSC.
Actually, my lords have 6 courses before your lordships. There were 53 applicants for the AFT. Before your lordships are 13, but AFT has considered 6 batches, my lords, starting from September 2010, going on to commissioned in June 20, September 13, my lords.
77.
And my lords asked this question, how many women were given? Kindly have that, my lords, for a moment. Your lordships may have page 135 for a moment. These are batches, my lords. These 6 batches are batches which have continued to be considered in a normal circumstance. Your lordships had directed a special dispensation for the first 3 batches, that is batch number 1, 2, 3, where, my lords, they could not be considered because there was no policy for permanent commission. This is batch 4 onwards. Batch 4, 5, 6, 7, 8, 9, up to batch 9. They have been considered in a normal course for PC along with the gentlemen officers, my lords. And at page 135, your lordships will see para 129, or my lords may like to hear him first, but your lordships asked this question, so I'm...
They say that they considered September 10 with March 2011.
They couldn't have, because as per the...
Where do you get it that you have to consider the same calendar year?
That comes from the policy itself. Because the policy itself says that the yearly intake to be considered.
Does the policy say
yearly intake? Yearly intake. Yes.
Page 278.
Yes. 238.
The number of vacancies for the batches within the year will be allotted.
That's correct. So how can you go to partly in one year and partly in the other? That's how it shrunk to 120.
Unless they had already considered March 2010 earlier.
But they couldn't have, because you had to consider it along with me. I am 2020. So 2010. So therefore you have to consider the situation inuring at that time. What the confusion occurred is, we were to be considered.
When it says in a year, it will refer to a calendar year, right?
My lords, I will have to show to your lordships a coordinate policy along with that, because the policy says they have to be considered in their 10th year. So anyone who has completed 10th year has already been considered, because they have to be considered in their 10th year of commissioning.
Well, my learned friend may ultimately satisfy your lordship. No, this is ultimately a statutory appeal. So it requires some consideration. No, I need to get a stay. Just a second. I need to get a stay. You don't bike and bike. In fact, Manoj, the table that your lordships have set out in Nitisha.
One calendar year. They're constantly at page, that internal page 239 is Bhatti.
Yes, my lord.
Everywhere they're referring to calendar year.
Well, they are referring to a year. This is a policy we were following since 1993.
Just see page 239.
Yes, my lords.
It says one calendar year.
239.
One calendar year is a unit.
My lord said 239, my lord.
239.
239, my lord.
The PDF page 279.
Yes, my lords. 239 says modalities for implementation of government order. Grant of so-and-so will be based on says trends in one calendar year.
You have this?
Number of PRC I'll file a counter. But my lords, your lordships will appreciate this is going on since 93.
I know, but file a counter.
We'll file a counter.
Well, I need some protection because some of these officers have been given release orders and they will otherwise be released in around 15th of September. So I was under interim protection right through, my lords. Protect me till the next date, or have it before 15th.
That I am opposing, my lords, for the reason.
Or have it before 15th of September.
Yes, no difficulty. We'll file our counter within a week, 10 days.
Keep it before the.
Please, my lords. But interim order, I'm respectfully.
Any officers who are presently in service will not be released till the next date of listing.
My lords, may kindly not say this, my lords, because they were not given extension on the basis of.
They're all in service.
No, they've been working for 14 years now.
Please see, my lords, these are 6 batches, my lords. How will we put our things in
All
order?
right, we'll see next time.
Early date,
We'll keep it in the first week of September.
But please protect me.
These are
we
batches.
have protected.
Essentially, these are batches which have now formed in the regular consideration. And if your lordships will have page 135 for a moment, your lordships will see that a substantial number of women officers, in fact, their ratio is much better than gentlemen officers. So, my lords, I must inform your lordships one more thing. At the time of entry, there are only specific number of women officers which are taken in because the requirement of men-women ratio. But in consideration for permanent commission, there is no consideration gender-wise.
All right, we'll have to consider the matter. It's just a first statutory.
I'm opposing an interim stay because then all officers fall in the same.
Keep it this side of the.
My lords, your lordships have passed that protecting me.
To the next date of listing.
Lordship. But I should not be released.
39, what is this? 39, you are appearing in 39 as well?
It's the same.
39 is the same.
I believe. Subject to my learned friends.
No difficulty. I'm here every day. Grateful.
Very definitely.
Thank you, sir.
I'm grateful.
Who's appearing? Item 40, who's appearing?
Your Lordship, I'm just requesting for a short passover since Mr. Muralidhar is handling the case and he is into other court.
The matter about to argue it. R1, who is the auction purchaser of the flat, has been permitted to pursue the application for intervention before the divisional joint registrar because they have acquired a valid title to the property.
So, Your Lordship, even if they have asked for the intervention, we are not denying. Let the intervention be decided by the deputy registrar. But the stay may be at least vacated because they have asked for the indefinite stay.
Because they have purchased the property in an
But the stay needs to be vacated.
But ultimately, they are.
Lordship, may I request you that Mr. Muralidhar is leading the matter?
Absolutely nothing in this matter.
Mr. Muralidhar is leading the matter. Just I'm asking for a short passover, Your Lordship.
41.
I'm seeking a
writ petition under Article 32, sorry. Writ petition under Article 32, claiming compensation. How can you file a petition under 32? You have to follow whatever. You have to file a suit, or if there's an arbitration agreement, an arbitration. There's no arbitration clause.
I kindly adjourn it for a few
No,
minutes.
it's not. Because we read it. I mean, we had that matter, you know, we burned the midnight oil. No adjournment. Chalo, push. 42.
The assets of a promoter which are leased to
We
a
have got
corporate.
the NCLT order. Where is the order? I was trying to look at it even today. There is no order.
The NCLT order is not
NCLT order.
NCLAT order.
LAT.
When we filed the appeal, the NCLAT order of 9th of July had not yet been uploaded. So a full second civil appeal has been put at the bottom of the first civil appeal.
Where the orders are next.
Yeah, where the order is, Milord. That is at PDF.
What we'll do is
275.
we'll keep it next Tuesday.
Very well.
Let's read the order because I was trying to struggle with where is the order, improved order. Keep it on.
The properties of the promoter being put to sale. Would Friday be this convenient, Milord, or
take it up?
Very well.
No, I am the caveator, madam. So,
Milord, till then, the liquidator will not take any further steps to sell, Milord. Just orally, your lordship may. Milord, the liquidator is putting the properties of a
completed and
promoter
implemented, madam.
to sale. And
All right.
status
We'll
quo.
All right.
Obliged.
Item 43.
Well, it's 43. High Court, not the country, not the police, no complainant, treats it in an unrelated matter as a suo motu glorification. If your lordship sees my articles, they actually have saved Salman Khan. They have saved other people. There's no glorification. And on freedom of speech 19(1)(a), if you start applying a glorification test, then there'll be no freedom of speech. And the High Court is dealing with some other POXO matter. In that, it starts making observations about people interviewing people in jail. Now see that, Balas. Kindly see if this will be the death of Balas free speech. The first Balas.
What is challenging here, by the way?
We have come in a writ for the reason that the High Court has passed order after order. I cannot go to the High Court. Plus, I am seeking a transfer to a central agency. I am seeking a transfer to a central agency because there cannot be the police are not prosecuting me. But under High Court, mandamus after mandamus, they are forced to prosecute me. I am a journalist. I am a journalist. Page 32 is my final prayer.
For a transfer of investigation to an agency under the union government.
That's right, page 32. And Malas, the reason is, give it to any agency, I don't. And how do I have a glorification, Malas? I'm sorry.
High Court says that you interviewed that gangster.
Yes.
And therefore, let an
glorification. See the interview. Actually, I extracted out of him the fact that he might attack Salman Khan, and Salman Khan got security because of my interview. He was attacked. My interview actually saved him. Now see that, Manas. This cannot be an interpretation of 19(1)(a).
Where is the impugned order of the High? Where is the order of the High Court?
And just let me tell you.
You haven't challenged the order of the High Court appointing an SIT.
No, SIT is appointed without hearing me, without hearing anybody. Anybody.
But you haven't challenged that order.
No, that's an SLP separately coming up. That's an SLP separate coming up.
Yeah, we'll hear that SLP. Why this?
This is because my fundamental rights under 19(1)(a), 19(1)(g). Kindly give me
who's on the SIT?
Now, two things.
Where is the SIT? Where is the SIT order?
Yes. The orders are on 23/12/23. Turn to 23/12/23. And the second order is 7th August 24. Blanket wide remarks.
Where are they?
Yes, 152 PDF. 152 PDF. 37. You stand here. Or if you also want both to come together, the SLP is coming on Tuesday or can be put on Tuesday. We can bring both together. It's futile to go to the High Court with these orders, and there's an interstate angle, Malas. I did another interview when he was in Rajasthan jail. And this man is supposed to have international ramifications. Now, Malas, the PIL he's dealing with a suo motu PIL on mobile phones. The learned judge is dealing with the PIL on use of mobile phones in jails. Nothing to do with me or the interview. In the course of that dealing.
Transfer it to a central agency. your SLP challenging an SIT in the first place,
Yes.
we'll consider it next week. But there's nothing
Then,
here
well, this is
for us
much
to
larger issue.
transfer it
There
to
are
a-
6
to a
judgments.
second.
Arnab Goswami, all that. Lordship will do one thing. Keep it with that. Let the SLP be taken up first. I'll just keep it there. Don't say anything on it. I don't want the rights of this. It's a much wider writ petition.
You're appearing.
Nobody, it's a writ petition.
40 minute, I will make a mention.
No, this is an original writ. Please put it on Tuesday. Put by laws, direct the SLP.
We'll postpone your judgment date.
Not the, don't postpone the inevitable. Malus. Give me a, here. I have Malus,
What's the SLP number?
SLP number.
This
give
is
it,
by
we'll give it.
diary number 361 of 2024.
Item 44.
Well, this is what your lordship said on 19(1)(a) in the Arnab Goswami. That's why well, there is an issue.
44.1.
Lordship, please.
This, if your lordship recollects, the interpretation of section 96 of the Insolvency and Bankruptcy Code, the effect of 138 pending that moratorium.
The High Court is relying on the judgment in Narinder Garg, right?
No, I believe your lordship has some other brief. 44.1 is listed today for interim. 44 has a fixed date.
Oh, 44 is
44 is already in December. It's a batch matter.
When is that coming up?
5th of December.
Oh, so 44.1 only is on board.
Only for interim. Only for interim.
Some of the other, I saw 44.
No,
I didn't see 44.1.
Order.
So 44.1 only, we will list next Tuesday so that we have an opportunity to read it over the weekend.
Your lordships issued notices on 5th minutes. Last time it was listed before your lordships. Your lordships issued notices, tagged it, kept it for interim today. Because Milods, my date.
If you don't mind, we don't have the 44.1. I have only 44. I thought only 44 is on. 44 is there.
All orders of
So we just
identical order.
We'll just take it up on Tuesday. We have not seen the papers.
Very well. It's Tuesday. Obliged.
45.
45, my lord, I have a personal,
clear.
due to change of guard, my lord, I need some instruction from the state, my lords.
Notice is issued, he has filed a counter for this, but.
All right, let him have a little time.
After 2 weeks, my lord, sir,
Take it out.
we'll get necessary arrangements done, my lords.
We have got this date with mentioning, well, lordship will give a specific date. We
It'll
will
be a
cover the
specific
lordship.
date. It'll be date time.
Fixed date.
Who's appearing?
We appear for the responding.
Should we appoint an arbitrator here?
No, your lordship.
Your lordship,
The person
your
who
lordship,
has
I'm,
arbitration, he has no authority to invoke.
My
the
lords, I appear
your
for
lordship, I'm
Concord,
appearing,
the
I'm
respondent.
appearing in item.
Yes, Mr. Shikiran. So you're for the
Please.
petition?
Your lordship, I am for the petitioner. I am appearing in item 46, your lordship. Your lordship, service is complete in this matter. And your lordship may give me a short date.
You're appearing.
My lords, I
I'm-
appear for Concord, the respondent. My lords, it is a case where, my lords, this matter has been filed without any authority. So this is, my lords, not maintainable.
The petitioner is a Chinese company.
Yes, my lords, my lords, they had given, my
Airport
lords,
companies.
they had given a power of attorney to Locofina, and that power of attorney was valid only up to the signing of the contract, before the signing of the contract. That is only to submit the.
Who has affirmed the petition?
I'm appearing for the petitioner, your lordship. Your lordship, I'm appearing for the petitioner.
Vijay Shekhar Malik, proprietor of Locofina.
The affidavit is filed by
petition.
Vijay Shekhar Malik, proprietor of Locofina.
Please, your lordship. Your lordship, he is the
Number
proprietor.
29 and 30.
Where is the authorization?
Your lordship, authority letter is already there, your lordship.
Page 29, your lordships. Page 29.
Please, your lordship.
Page,
Yes.
the PDF, page
All right, let's
46.
read that letter. Let's read Jinshi Axel Company.
Page 46.
PDF page 46, your lordships.
Ecofina to represent us to bid.
Show me.
Also,
Authority only
this
to
is not
negotiate and
signed.
conclude the contract. Where is the authority?
29, Annexure P1.
Letter in document. Even this letter.
Page 29, but it's
Annexure P1 is your lordship. Annexure P1 is authority letter.
to represent us, to bid us, negotiate and conclude the contract on our behalf with you.
Please, your lordship.
Where is the authorization to file a petition under section 11.6? Only if this is only in respect of bidding for the contract.
Your lordship may just submit. Your lordship may just give me 1 week time, your lordship. I will appear physically and will argue this matter, your lordship.
Physical, absolutely physical. You are here. We can
Please,
see.
your lordship. Please, your lordship. So, your lordship, this annexure P1 is the letter. This is a pro forma for authority.
Arbitration
From
petition.
manufacturer.
Section 11.6 of the Arbitration and Conciliation Act has been filed on behalf of a Chinese company by Sri Vijay Shankar Malik. Full stop. The purported letter of authorization into bracket annexure P1 dated 15 April 2024 is in the following terms. We, page 29, we Jinxi Axle Company se lekar on the next page up to 2014. The exfacie, the letter of authorization, authorizes Sri Vijay Shankar Malik to represent the Chinese company to bid, negotiate, and conclude the contract on behalf of on their behalf against a particular tender. Stop. There is no authorization to institute a proceeding under section 11.6 of the Arbitration and Conciliation Act 1996. Would stop. The petition is accordingly dismissed from that down. Item 47.
My Lord, I appear for respondent number 1 state. My Lord, we have been served. My Lord, we have filed our wakalat, which we are filing now. My Lord, we need some time to file, my Lord, counter.
Yes.
I know. 2 weeks will give them to file a counter.
Very well. Just one respondent, who's the brother of the chief minister, he remains unserved according to the office report, R6. Your lordship may allow us to, in the meantime, serve him thusly. He is respondent number 6.
Okay. We'll file it in 2 weeks.
Yes, my Lord, we should do it.
Right? And liberty to serve the 6th respondent, Dusty.
That's
the unserved 6th respondent, Dusty. 48.
Please.
Your lordship may fix some dates.
Yes. After 2 weeks, we'll pick it up.
Very well.
Justice Shahi.
Please.
Thank you for joining in. Justice Shahi, now what is the position insofar as the National Consumer Disputes Commission is concerned? Justice Shahi, you may have to unmute yourself. I think your team can just unmute you.
I will request your lordships to kindly have internal page 5 of my report.
Yes.
Your lordships will find a rollout plan charted out therein.
Additional file.
Rollout plan, right?
Yes, yes, my lord.
Station of e-Jagriti to NCDRC, yes.
Now, this rollout plan is slightly being delayed on account of certain data issues, data migration issues, which is item number 2.
Yes.
That is yet to be supplied by us. So this timeline has been slightly crossed by us, and we will be doing it very soon. But the timeline given by them is 15th September.
Right.
So I will request your lordships to kindly have this matter after 15th September. And by that time, we will be able to demonstrate before your lordships as to what is the progress in the matter.
I'm sorry, Lordship.
Because this case, this entire report has no concern with my case, Lord. This is nothing but the upgradation of the electronic system or the software.
But your writ petition assails the continued practice of physical filing before the consumer fora, right?
My only submission, Lordship, as far as the litigants and advocates are concerned, we are already filing every document online. And it is nothing but only the matter of the printing from our side, which is required for the NCDRC or not. Even we are filing the written arguments, and there are two NIC officers there, which are uploading their documents.
What is the grievance actually? What is your
My grievance, Lordship, that advocates and litigants are filing online as per the requirement of NCDRC, as per their notification. Then thereafter, we are bound to file in the physical form also.
Yeah, all right. Justice Shai, after the advocates filed online pleading, does the NCDRC require them to again file physical copies of pleadings?
The reason is that we have not been able to connect and we have not been able to convert ourselves into an e-court because of the transformation of the system. Now, previously it was e-dakhil. Now they are converting to e-jagriti.
So are you
now this is,
are you anticipating that by 15 September this need will come to an end once you have migrated to e-jagriti?
yes, we are anticipating it, but it might take some little longer because of this data migration problem, which has
just a solution, Lordship.
Yes.
As we are in this court adopting the system, that advocates and litigants are now paperless. We are filing everything paper. And most of the courts are also paperless. But if the courts are required printed paper books,
then they must do it, you say.
They have already the facility to take the print out the document, because I am just telling you the Lordship what is going on.
Justice Shai, the learned counsel is right. Once advocates are filing in the online mode, then why should we expect them to file physical copies? Then if a court requires physical copies, the burden is for the court to discharge. Because if otherwise, otherwise lawyers will say, why do we have to file online copies if I have to file physical copies? And I'll file physical copies. That was a
now if
also 2 years ago.
we are to generate
very well. Actually,
actually the data is the entire feeding and the system to migrate this information which is being received on the e-Dakhila platform. We are not as yet well equipped so as to convert it into the e-court system, and we have to necessarily bank upon a physical filing system for the time being.
But then physical printing should be done by the tribunal.
So now that will come as expenses and additional staff.
Sorry?
That will now entail additional expenses and additional staff for that purpose.
No, I'm sorry for it, Lordship. There are 4 staff for scrutinization of e-filing or fresh filing or even online filing. There are 2 officers of NIC who are uploading our e-filing to the connected system. They are saying that it could not be filed, could not be uploaded to the.
One second. Can you just look into it, Justice Shai? Because if we are asking the members of the bar to be compliant on the digital platform, then we shouldn't then merge or saddle the bar with the additional obligation to file physical copies, because then that defeats the whole purpose. If at our level as courts we have some migration issues, as you are saying, then in the meantime, if you require physical copies, the NCDRC must take upon itself that burden. Why ask lawyers to do it? They have filed in the electronic mode. You have two NIC officers, he says.
No, the NIC officers keep on reducing and increasing at times, but nonetheless, this will require at least 4 additional staff, and then of course the expenses for getting the physical copies generated and printed out. So that will be, we will have to have an additional setup for that.
I'm sorry for
it. Shai, 1 second. Just Shai, we also realize your difficulty. It's not an idea.
Yes.
We'll take it up on Tuesday. If you can just sort it out in the meantime with the Secretary in the Ministry of Consumer Affairs. Because we quite understand the concern of lawyers that, look, you don't ask us, we are moving into the digital world. But on the other hand, we put the burden on the lawyers to also do the paper filing. Then why have digital filing at all? They're right, actually. We had to dispense with it in the Supreme Court 2 years ago.
Now, unless we have the entire system in place, the NIC is doing it, and we are going.
Is it possible to just have a little patience till
just telling
15
you,
September? Just
I'm
try
just telling
saying,
you,
give me
Lordship,
time till 15 September, I'm sorting it
I am
out.
very well, Lordship, but I am just telling you what is going on.
We know what is going on and we realize the problem, but there are also practical problems. NCDRC is not the Supreme Court. We have a certain degree of authority, you see, so they have to deal with other governmental agencies. So if you don't mind, we'll keep it after the 15th of September. Let Justice Shai sort it out. You know, he also has a problem on hand. The President also realizes the problem. In fact, we have requested Justice Shai to join in only. It's not an adversarial thing, but just to streamline things.
It's all right. I'm there to assist.
We take it up after 15 September. Now, Justice Shai, please have a meeting with the Secretary Minister of Consumer Affairs and sort it out. You know,
Lordship, there is one
we'll
more.
also have a conversation on this.
Lordship, there is one more concern that the state consumer commissions are also here party. We have no e-filing system. They have not started yet.
Lordship, I appear for R4, Your Lordship.
Only one respondent is appearing.
Through e-Dakhil in state of district.
Who's appearing for the government of India, actually?
Nobody,
Ministry of Consumer
nobody has filed the wakalatnama. State Consumer Commission, State Consumer Commission.
Justice A.P. Shahi, President of the Disputes Redressal Commission, has appeared, has participated in the proceedings through the video conferencing platform, so as to apprise this court of the progress which has been made for the migration of NCDRC to the e-Jagriti platform. Full stop. In the tabulated position which is indicated in the status report, it has been indicated that the launch of the e-Jagriti platform for NCDRC is expected to take place from 15 September 2024. Full stop. Based on the above, full stop. We find merit in the submission of the learned counsel for the petitioner, however, that since members of the bar or litigants are filing proceedings online, they should not be mulcted with the additional obligation of filing paper copies, physical copies. The problem, as it persists at present, is expected to get resolved once the e-Jagriti platform is launched on 15 September 2024. Hence, these proceedings shall be listed on, taking the first miscellaneous day. None appears, there's no appearance on behalf of the Ministry of Consumer Affairs.
And Lordship, State Consumer Commission.
Lordship, I appear for R4.
It appears that in most state consumer dispute redressal commissions, there is no provision for e-filing.
Your Lordship, they are
In most, yes, you are appearing for?
Uttarakhand, Your Lordship.
However, learned counsel for the Uttarakhand
Yes, Your Lordship.
SCDRC states that provision has been made for e-filing.
Yes, e-Dakhil, through e-Dakhil.
But also taking the paper copy, Lordship.
That's right.
Full stop. We direct the Secretary in the Ministry of Consumer Affairs to assist this court by appearing online on the next date of listing and to ensure that there is appearance on behalf of the ministry before this court on the next date of listing. Full stop. In the meantime, all the state consumer dispute redressal commissions shall take necessary steps to actively set in motion the migration to the e-Jagriti platform, as in the case of the NCDRC.
Lordship.
We'll list on further. We'll push it along. These are things, you know, this is work in progress. We have to push everybody. Right? It's pointed it out so that there'll be some progress on the ground.
But
thank you, Doctor. Thank you, Justice Shai.
Lordship, date may be fixed.
20th September. We'll take it up on 20th September. Justice Shai, just follow it, you know, so that the e-Jagriti is activated.
Yes, my lord, there is just one more request, small request with regard to the functioning part of the commissions throughout the country. We have been facing a lot of problems with regard to non-appointments, and that issue is engaging your lordship's bench. It will please your lordships to kindly take up that matter and other connected matters so that that issue is resolved, because every day we are having a lot of problems on that.
Justice Shai, can you have the registrar just give us the number of that matter to the court master right after we rise, so that?
Yes, yes, I shall do that, my lords.
Laga do matter. We'll take it up early, Justice Shai.
All right. Thank you, my lord.
Item 49. In 49, your lordship said issued notice. Now state has not appeared.
Yes.
If your lordship may permit, we will.
Serve the standing counsel of the state.
If your lordship permits, we may serve the standing counsel here. This is from Orissa.
I beg to differ. Private respondent, Mr. Parija is leading him.
Lord, I appear for the private, for our 5 minutes.
You're for the petitioner.
Petitioner, your lordship.
Because
Your lordship, recall the matter, here the tender as a whole was cancelled. Now the Honorable High Court says a show cause notice had to be issued to the tenderers.
No. Mr. Parija.
Yes, madam.
The second tender process was cancelled. Now, what is the reason for the cancellation of the second tender process?
The second tender process was made subject to the result of the litigation. In the counter affidavit,
The first was cancelled and the second was issued.
the second,
Court says they should have been given a hearing before the first was cancelled. Where is the requirement of a hearing before a tender?
the High Court says 2 things. High Court says no reasons assigned, and High Court says that a hearing was to be given. Your lordship may take it, no reasons assigned. Now, would your lordship see what was the reason assigned? And kindly see, my lords, page 85. My lords, of page 85, my lords, annexure P4.
Yes.
Kindly see, my lords, this is 11th of December 2023. The tendering authority is writing a letter saying, inviting kind reference to the subject cited above, it is to state that the first lowest percentage tender of so and so, that is me, Mills, is 47.58 crores, only excluding the application of GST minus so and so, is hereby recommended for consideration of approval by the government in the works department as per para 6.3.154, note 1 of the OPWD code, volume 1. The details of the tenders have been elaborated in the checklist enclosed. The tender is valid till 11th of March. Now kindly see the next page, page 86. What does the tender committee do to this? And if your lordship sees, minutes, it says Chief Engineer DPI Roads has recommended the lowest percentage tender of so and so, amounting to rupees 47.58 crores, only excluding GST being 2.10 less than the corresponding estimate cost of so and so, put to tender as per so and so. The project cost is administratively approved for an amount of 5923, that is 59.23 lakhs. The project cost is technically sanctioned for an amount of 48.60. The chief engineer has indicated that
R124 filed their counter affidavit opposing.
No, they haven't. They haven't. But if your lordship sees, yes, they did. And if your lordship will come, no, Milord, in the High Court, Milord, in the High Court,
rate of steel, bitumen, emulsion, etc.
Your lordship, page 173. Your lordship asked a very pertinent question. What was the counter in the High Court? That is P13, page 171.
We'll do is, we'll require some assistance from the council for the state of Orissa. We'll serve the standing council and come on Tuesday.
Milord, we do not have a standing counsel for the state of Orissa. Mr. Sibasis Misra is the senior most advocate on record. So your lordships could direct them to take notice on him. State of Orissa does not have a standing counsel.
But we can't also ask notice to be given to a senior counsel.
The Sibasis Misra is the senior most AOR. That is all I was saying.
Senior most AOR, all right.
Yes. I know a little bit about this, Milord.
There is no appearance on behalf of the state of Orissa. Full stop. Despite the notice which was issued on 12 July 2024, the office shall intimate Mr. Shibashish Mishra, who normally appears on behalf of the state of Orissa as AOR, intimating him that the proceedings are listed before this court on Tuesday. Keep it next Tuesday, we'll let him come here.
But a copy may be served by the petition on Mr. Mishra.
Copy of the petition may be served on Mr. Mishra by the learned counsel for the facts.
Grateful.
And the interim order to continue.
Interim order to continue to the next.
Lordship.
Item 50.
May it please, my lords. My lords, we have served the respondent on 1st August itself by email. We've also initiated the process for serving through the Hague Convention, my lords. There was a delay of 5 days. We filed an application as well, which has been numbered but not yet listed before the registrar, my lords.
All right, then we keep it after 2 weeks to ensure that the necessary orders are passed by the registrar, and then you can effect service on him.
Very well, my lords.
All right.
Obliged.
51.
May it please, my lord. My lord, this was for appointment of substitute arbitrator. Service of notice stands completed.
He had recused herself.
That's right, my lords. It was at the stage of final arguments, in fact, my lords, and Justice.
Where is the arbitration taking place?
My lords, in Delhi.
Delhi. How much is the stake?
My lords, it's about $2 million.
This is G. Rohini, who is appointed as an arbitrator, has since recused. Has since indicated her inability to continue with the arbitral proceedings. We'll stop in this view of the matter. Comment. An application has been filed for the appointment of a substitute arbitrator. We'll stop. Shri Justice Badr Durraiz Ahmed, former Chief Justice of the High Court of Jammu and Kashmir, former judge of the Delhi High Court, is accordingly appointed sole arbitrator. Right?
Yes, my lord.
Sole arbitrator under the Arbitration and Conciliation Act 1996. This is an international commercial arbitration.
This is international commercial arbitration, my lords. Very deeply obliged, my lords. Because the arbitral record will need to be transferred.
The arbitral record may be transferred to the substituted, the newly appointed arbitrator.
Very deeply obliged, my lords.
Please cover the national commercial arbitration.
Please, my lord. Item 52, my lords, is seeking appointment of arbitrator, my lords.
I've entered appearance as of this morning. I filed my wakalatnama. I'm not sure if it's on record, but my instructions are to request your lordships to kindly refer the parties to mediation. We are hopeful that we'll close it at best in 2 sessions. Unnecessary cost will be avoided. It's just a question of sort of reaching on certain milestones. Would
you like to attempt a mediation for 2 weeks, and then we can list it if nothing resolves?
Sir, I bow down, my lord.
What we can do is this: we'll appoint an arbitrator. We will say parties will go to mediation. If there is no result in the mediation, say by 15th, we'll say by 15th of September, then the arbitration to proceed. We'll give you enough time.
I beg to.
That would be ideal, my lord.
At the moment, because it's in the spirit of compromise, the option of referring to me.
All right. Parties have agreed to explore the possibility of a mediated resolution of the dispute. They shall accordingly appear before the mediation center of the Supreme Court next Tuesday at 2 p.m.
Grateful. What we've noted is once there is an arbitrator in place,
parties shall be listed before this court on, keep it after 3 weeks, so that the court is apprised of the status of the mediation.
Certainly.
3 weeks we'll list it here.
Very well. Deeply obliged. Grateful.
Well, this is that PG admission to AIMS, my lords.
Who's
It will
appearing?
take some time. Lordship
will
can
take
have it
some
on,
time.
yes, my lords. We have it circulated as small note. Can it be had on Thursday or Tuesday, my lord, subject to your lordships?
Tuesday we'll take it.
Very well, my lords.
Yeah, we'll take it on Tuesday. Miscellaneous meeting will invest.
Please, my lord. One request, my lords, if it could be accommodated as
Yes,
top
we'll
of
take
the
it up
board.
higher this time.
Very well.
It's higher so that today
Deep.
the first half went in that matter.
I know.
Yes.
Deeply obliged.
Open round of counseling is over, my lord.
My lords, you can't put equities against me
Anyway,
after
we
taking
get
it.
it.
That's
Yes,
not done.
I'm so grateful. Grateful, my lord.
Obliged.
Deeply obliged.
An order of the arbitrator under section 17 directing the petitioner to furnish a bank guarantee. I speak to for dismissal. What locus did he have to challenge the tender to be dismissed? 59, na?
Go backward. This is that West
West Bengal backward. वो tag हो गया है उसके साथ.
Your Lordship, I'm appearing in item 58.
Yes, 58.
Yes, please, Your Lordship. It's a direction by the arbitrator for deposit. Without dealing with Ramantek, Your Lordship, he says that Ramantek will not apply to arbitration proceedings. Because as of this stage, there is no finding on the aspect that...
How much is the bank guarantee? What is the quantum of the bank guarantee?
4 crores, Your Lordship.
These are matters within the discretion of the arbitral tribunal.
Your Lordship, I'll just show one paragraph of the impugned judgment, para 5, that's all. I'll just beseech Your Lordship to see that. Because instead of filing execution, they're filing contempt to arm twist me. Para 5 of the impugned judgment on page number 4. Faces the above, if I may read that paragraph. Clearly says that is a precise exercise that should be avoided, that the parties should not try to arm twist the other one using the powers of 38.5 CPC.
He submitted per contract. Today, then submitted.
Because that was my submission, they have filed contempt. Now, if the Lordship were not to allow my petition, they will file a contempt, say that amount has to be deposited.
Page of section 17. That's why the arbitrators must have the autonomy to decide.
Lordship, then contempt power is being used to arm twist people in arbitration. That is also not the premise for which arbitration should be there.
All right. Thank you. Will not interfere. Item 16.
Please, madam. I'm only outside of the ground of locus, madam. Specifically, now
the what is your challenge to a tender?
Tender. I'm also contractor.
Or Balasaheb Thackeray Haridra Turmeric Research and Training Center project.
Please. And in that context, basically,
how are you concerned with the?
I'm also contractor working in that area, that particular area, and moreover, now concept of locus also a lot is it is widened to great extent.
What is your? I know, but what is the problem in these PILs? Is there's some other motive behind it?
No. There is basically, earlier tenders are issued, then by a corrigendum, that undated corrigendum, that tender is cancelled, my lord, and subsequently, my lord, awarded to completely different reasons. My lord, I didn't participate, but for the reason certain glaring aspects are pointed out, court at least would have examined those aspects. My lord, 30th petition is filed, 31st immediately next date on the first date of hearing. Now, court of first instance, my lord, High Court should have at least examined the issues which are raised, my lord. And there are something, page 42, lordships may have for a moment, my lord, page 42. I was this corrigendum, my lord, that page 42, the entire tender is cancelled, my lord, which was initially floated, my lord. And this is the undated document.
It's the participated.
Mulad, I can at least point out, Mulad, basically, because I am a contractor. It's not that I'm some rank outsider, Mulad. I'm also a contractor working in that particular area. And then next page, lordships may have page 43. Now, subsequently, a new tender is issued, Mulad. Now, this is Akola area. Now, the region where the work is going on, Mulad, this project in question is.
You had submitted a bid for the first tender?
No, I couldn't submit for the reason.
For the earlier tender?
No, I didn't submit, Mulad, because it was unilaterally cancelled by virtue of this corrigendum, Mulad, page 42. And Mulad,
you don't submit a bid for the first tender.
No, I did. But then, Lordship, see the glaring irregularities, Mulad.
Not a PIL also.
No, it's not. But in the sense, I bring something to the notice of the court, Mulad. 226 High Court should have taken, should at least examine this, Mulad, is what I submit.
Dismiss, yes.
I am grateful.
61 का क्या हो गया भाई? हाँ? भाई ये 60 अभी थके.
I'm sorry. Lord, please see page 117. Lord, in fact, the first appellate court decides something in my favor.
Sorry?
First appellate court says, Lord, considers everything, Lord, from page 116 and says, please see page 116.
Initially, the district judge, by the order of 20th February 23,
yes,
stayed the eviction till the disposal of the appeal, subject to the condition that you would deposit 5.5 lakhs per month from the date of the filing of the application.
Yes, my lord. And
thereafter, your appeal has been dismissed.
Dismissed.
Now, when you file,
I file a writ petition.
In that, the High Court says you must deposit 5.5 lakhs with effect from the date of the decree.
Yes, from the, my lord.
But he has to be protected, right?
No, he has to be protected. My lord, I have no problem. I am paying 5.5 lakh. From which date? My lord, because the first appellate court, which says from the date of application, without there being any appeal from the other side. My lord, other side has not challenged it.
That order was pending the disposal of the appeal by the first
No,
appellate.
in the final hearing. My lord, please see page 117.
Right.
Page 118. It's at the final hearing.
Just
Please,
1 second. Let us see that.
Page 118.
Page. Just give me a moment. Annexure.
किथे annexure पे? Annexure P9. Lord, please see page 116 at para 17. 17 onward.
The execution of the decree in civil suit shall remain stayed.
Yes.
116, is it?
Yes, from 116, my lord, please see.
Para?
In fact, my lord, 115 onwards.
Para 17.
Yes, my lord. In fact, my lord, from para page 115 onwards, he considers everything. My lord, para 13, if your lordship sees, according to the respondents, as contained in the valuation report filed on behalf of the present value of the suit property, that is 2023 valuation, is 11 crores as ready reckoner rate. The property is situated in the prime locality of city Pune, that is so and so. Therefore, the calculation, the compensation comes to 10 lakhs so and so. Now, next para. On the other hand, advocate so and so, appearing on behalf of the appellant, submitted that the valuation report stating that the rental value of the property is rupees 2,34,000 per month. Now, next para. In this behalf, it appears that it is not seriously disputed by the appellant that as per ready reckoner, the valuation of the property is 11 crores. However, according to the appellant, while calculating monthly compensation, 60% depreciation value is to be deducted while considering the present market value of the for calculation. According
so, para 21.
Now,
it says in these set of facts and observations of the Honorable High Court, it would be justifiable if the landlord is held to be entitled for such compensation from the date of the present application and not from the date of the decree.
Right. It considers, from para 16, it considers all these judgments. Even Atmaram properties is considered. Para 17, it says, Lord, para 18, I'm sorry. Para 18 is very important, Lord. Para 18, if your lordship permits me to read, at page 116. May I read, Miller? Para 18 and 19 are important.
But you have challenged the decree for eviction before the High Court in a writ petition.
Right, Miller.
Right. Now, while granting a stay of execution, the High Court can certainly condition its order by saying that you must pay that amount of 5.5 lakhs from the date of the decree.
The reason why the first appellate court says something in
First appellate court says from the date of the application.
No, the reason
the High Court thereafter, while granting you a stay, says, but you must deposit from the date of the decree.
Miller,
where is the property? Where is the property?
Property is in Pune, MG Road. MG Road.
MG Road.
Yeah, but plus.
How big is the property?
6,000 square feet. 6,000 square feet.
How much? 6,000 square feet in MG Road. My God.
I'll just tell you.
In camp.
I'll just tell you. Lord, please see para 18. I just wanted to show. Lord,
what are you running, by the way?
Sorry,
what are you running?
It's a Bombay store.
Bombay store?
Yes. But
oh my God.
That is not.
You have to just go to one of the Bombay stores in the fountain area.
The point is this. Please see this. The point is this. Lord, there are three things which the first appellate court considers. Lord, permit me to say this. Just okay. one sentence. One more.
There's a decree for eviction against you. You have to make good that you have to deposit 5.5 lakhs.
Lord, 434, less than 5,000 square feet. What is it? Lord, less than. But first appellate court says you can't apply valuation of 2023 for 2015. So that is the reason why, my lord, please see this.
Result of the appeal.
But my lord, it won't be. I'll have to pay as an arrears.
Deposited.
Then may I say something? But because the High Court doesn't apply its mind, it doesn't consider all these aspects. My lord, may I make an application before the High Court?
They've got a decree for eviction.
No, that's true, my lord. May I make an application before the High
Petition
Court?
will lie pending there for the next 10 years.
No, it's listed tomorrow. It's listed tomorrow. The court said within 4 weeks you deposit and that is listed tomorrow. Therefore, what I'm saying is this, man. There are two things which I'm requesting your lordship to consider. This is an alternate prayer. I'll make an application and justify my stand that 2015 the valuation was not this much. And two, I'll further request the court for
1,000 square feet.
no 5,000, less than 4,500. I just checked it, 4,500.
Which you are paying the contract.
5,50,000 we are paying.
No, the contractual rent.
Oh, sorry. 2,31,000.
When was
We
the
are paying,
property?
5,50,000 we are paying. We have deposited arrears from
You have to
2022.
now go back to the date of the decree.
Yes, that's the problem.
When is the date of the decree?
2015.
2015.
And it will be more than 5 crores. So therefore, what I'm saying is, consider, may I say one thing? I'll just make an application before the High Court and point out, 2015, it was not the valuation. That was not the valuation.
Ask not, we're not.
Then may I say one more thing? The period is given till tomorrow. May I request, give me
That you tell the High Court tomorrow.
4 more
We
weeks.
undertake to deposit, extend time. We just got our SLP. was-
Then may I request, permit me to make an application at least. Otherwise, court has said deposit by tomorrow.
For extension of time, you can certainly tell the High Court. You can go there. No difficulty. We'll discuss.
Very well.
62.
Then I'll withdraw it and file an application, for extension of time.
No. We'll discuss it here now. Let this part get over.
Very well.
Yeah. 62.
May it please, Mona. So will your lordship have page 22, Mona?
We have also referred to the fact that all the media houses, everything that the victim's name, her photographs of the.
I see that is the way before your lordship,
postmortem.
Lord, that your lordship's judgment in Nipun Saxena, the Ministry of Home's directions of 2019 are still not being implemented, my lord. The name, the identity, the photographs, the photograph of the body, which was all these are viral, my lord.
On 16th August, the High Court has already directed the members of the press.
Well, that was
media
only
to
a
ensure that
request.
the victim-
There is no direction. There is no positive direction. No, it's only a request by the High Court. So today, my lord, it's lakhs of these views. Hash.
We have said that.
No, your lordship, my lord, have only constituted the task force, my lord, and the CBI to submit a action taken report to your lordships on Thursday. This part, my lord, your lordships.
Petition by actually.
Well, these these are two lawyers, my lord, who originally belong to West Bengal, my lord. They practice here, my lord, in Delhi.
The grievance which has been urged in the petition under Article 32, which has been instituted by members of the bar, is that following the alleged rape, following the murder, brackets coupled with an alleged rape, bracket, which took place at RG Kar Medical College and Hospital, the names of the deceased, the name of the deceased has been widely disseminated on electronic and social media platforms, including Meta, bracket Facebook and Instagram, bracket Google, bracket YouTube, and X, into brackets formerly Twitter. Victim's name or related hashtags, full stop. Moreover, it appears that the photographs of the body of the deceased, including video clips, have been circulating on the social media and electronic platforms. So plainly, this is in violation of the directives of this court in Nipun Saxena versus Union of India. What's the citation? 2009 to SCC.
It was 2019-16.
To SCC 7, where there was a direction Stop. This court directed that the identity of victims of rape should be protected and no media, including the press, electronic and social media, will reveal the victim, the identity, will reveal the identity. Stop. A directive was also issued by the Union Ministry of Home Affairs on 16 January 2019.
Please, Manoj.
What does section 72(1) of the Nyaya Samhita say?
Well, it's identity of the victim should be kept, Manoj, protected, Manoj.
Reliance has also been placed on
Manoj, it's at page 17, Manoj, of the petition. We are today, Manoj, at a stage where it is the offence is alleged. Whosoever prints or publishes the name or any matter which may make known the identity of any person against
is alleged or found to have been committed. And 63, 64, 65, 66, 67.
These are rape, Manoj, punishment for rape, and
Reliance has also been placed on the provisions of section 72(1) of the Bharatiya
Nyaya Samhita, Manoj.
2023. Next. This court is constrained to pass an order for enforcement, since it is apparent that the social and electronic media have proceeded to publish not only the identity of the deceased, but photographs of the dead body at or around the time of the post-mortem.
Well, after recovery, after the body was recovered.
After the recovery of the body. Full stop. We accordingly direct that all references to the name of the deceased victim and photographs and video clippings shall forthwith be removed from the from all social media platforms, including electronic platforms, in compliance with this order. Full stop. Now we can dispose it off on this. We are disposing it off. No point in giving notice to Union of India.
No. The union is only tasked, no, because it's only.
Yes, that's right. We are disposing it off.
Please, no. Please, no.
An important matter for interpretation of a section of the Trademarks Act.
The cross suits have been consolidated here.
Yes.
And yours was the application for dismissal of the suit by the respondent, which has been rejected.
That's right.
Why did you want the rejection of their suit?
Because that's a consistent view of the two division benches of the High Court and this court. No? That as soon as the suit, because I serve him with a legal notice, he comes back with an illegal threat suit. The moment I institute a properly instituted infringement suit, 142(2) says that suit must fail.
He filed a trademark suit against you.
It's for illegal threats. I serve him, but he infringes my mark. I serve him with a cease and desist notice.
Right.
He counters that by saying your threat is illegal. Now, surely when I initiate a suit for infringement, my threat can't be illegal. So 142(2) of the Act says, and the consistent view of courts is that suit must fail now.
Because I can't. This suit was only for
illegal threats.
For illegal threats.
Yes. And that threat can't remain illegal if I have now instituted a suit. So it is that I must not continue making illegal threats without seeking recourse to law.
And you filed now a suit for injunction.
For infringement and injunction.
For infringement and injunction.
Yes.
You are a registered.
I'm a registered proprietor. And he, in fact, even the parties are not the same. He adds another party.
We'll at least consider what they have to say.
Very well. But my injunction is not being heard because of this. That's my only.
We'll keep it in 2 weeks.
Because it just sets a very wrong precedent. Because when we serve, because I'm just pointing out because courts encourage us to write to the other party first, so that maybe we can settle. And if they come back with counter suits, it will just very well after 2 weeks. Grateful.
64 is after notice. It take a little time.
No, I had made a request only because the main Rajasthan, this is for persons with disability where I'm assisting your
I know.
lordships. So I'm only praying for an interim, small interim order if it meets with your lordship.
Yes.
Can I indicate in
Yes.
Rajasthan what has happened? Rajasthan makes a reservation for persons with benchmark disability of 4%, which means 9 seats out of 222. Lordship may just bear with me, 9 seats.
Out of 220. This is Rajasthan High Judicial Service.
Lower judicial service. So not lower, civil judicial service at the entry level.
9 out of 122.
222 are reserved minutes.
4%.
Persons with benchmark disability are reserved minutes. Now, just one more point, minutes. For preliminary exam, 40% is the marks given for qualifying. So if you get 40, a person with benchmark disability gets 40%, he will be eligible. Lordships have that minutes.
Yes.
Now, preliminary exam is held, results are declared. Large number of people with benchmark disability would have got 40%, 45%, 50%. But none of them are actually made eligible to the main exam because they do not declare a separate cutoff for persons with benchmark disabilities.
But all of them got more than 40%.
Large number of them would have got.
You people have.
You
mean that these people have.
The petitioners have. I'm only assisting as an amicus.
Right.
Some petitioners have filed their list of the documents to show that they have got more than 45. The large number of lordships, therefore, I'm only assisting the lordship. Somebody has
got more than, no cutoff has been declared. According to you, the cutoff must be lower than the 40%.
Right. No, Milos. So what they did, Milos, they said now you are competing with general category. So if you're a general category person with disability, you must get 73 marks. If you are a SC/ST, you must get 60 marks. So that's what has happened, Milos. Page 244.
But the reservation is what? Horizontal?
Horizontal. So for women.
So you then have to have the cutoff marks in that category.
Yes, Milos. So out of 9, 15 times they have to call for the main exam. 15 times the number of people vacancies. So if you have 9 vacancies, you have to call 135 candidates for the main exam. To take 135 of the persons with benchmark disability, they have only taken 11. Because what they did, they said if you are a general person with benchmark disability, 73 is the cutoff. So 40 is otherwise the qualifying marks, but now you put the person with physical benchmark disability and make him compete with the general category. So
though they've got cutoff.
Yes, Milo, though I have got minimum qualifying. So just see the
they say that the last person in the general category is 73 marks.
Yes, Milo. So therefore you stop.
So 73 is not a cutoff as such. It's really a de facto cutoff.
De facto cutoff for a person who is a general category person with benchmark disability is said you must
get. Appearing for the Rajasthan High Court?
I appear for the High Court, Malad. This issue is subject matter of another civil appeal 5051 of 23. That matter, my lords, was heard at length, and on 7th of August, this Honorable Court has reserved judgment on it. I have, with my count.
For Rajasthan High Court itself?
For the same selection process for Rajasthan High Court.
Same issue?
Yes, because they are wanting a separate
cutoff. For which bench was that?
Justice Bela Trivedi's.
Is it the same exam or different exam?
They were petitioners.
Earlier exam?
No, but they moved an IA because that process of 2021 got completed. They moved an IA, even questioning this current process.
That Trivedi has reserved orders. Let's await orders.
The only thing is exam is on 31st August. But that's why I was listening.
But keep it next week.
Right.
Just let's see if the judgment comes.
Right.
Because if the exam is by 31st, it's all likelihood that sister would have delivered the judgment.
Right. Even admit cards are out, Malad. That's that notification.
We'll keep it next Tuesday. We'll also find out.
Yes, yes.
One Passover. In that time, we'll have guidance then for what.
Yes, Milos. If it doesn't, the judgment doesn't. I was only saying they can start processing, Milos, for 135 candidates. They'll have to, Milos, today exam is say 10 days away. They can start processing. If ultimately your lordship decide no separate cutoff is there, they won't take the exam. If your lordship decide this way.
How many candidates are there?
So therefore, I think 135 should be allowed to take part. But suppose somebody doesn't get 40% in the qualifying.
Can you do this? Just check. In case Sister Justice Bela Trivedi's judgment comes, in the meantime, we are governed by that judgment. If it does not, then we may decide to make some pro tem arrangement, so that ultimately, you can just give us a small chart, maybe a one-page note. How many such candidates are there? So that you can process their names without equities, if they ultimately they fail, they fail.
Because these petitioners have not qualified for the mains, but 11 persons with disabilities have qualified for the mains.
And that is because you're taking the cutoff at 70.
Because they have crossed 73.
They are anyway general category, my lords.
These are people who are above 40 but below
Yes,
73.
yes, yes. my lords.
Because the difficulty would be a separate cutoff would mean a separate vertical category. That was what was.
We got the point, you're right.
But they have precise cutoff for women, my lords.
Anyway, let's await Justice Bela Trivedhi's judgment. We'll keep it on Tuesday. But we just keep a one-page note ready for us, the factual note, because for the High Court we'll have.
Yes, my lord. Just a clarification for other horizontal categories, they have provided cutoff. For example, women divorcee.
Separate cutoff.
Cutoff, women divorcee
That is
68. Women widow is horizontal 45. So a person who's a woman who's a widow has 45 marks.
A woman who's disabled will not get it.
Women who are disabled who general
That was
category
also
won't get it.
argued, my lords, that is a compartmentalized horizontal. My lords, the difference lies in an overall horizontal and a
If
compartmentalized.
you're providing a separate cutoff for other horizontal reservation categories, then why not for the
The difference is it is a compartmentalized. Within the vertical categories, there are seats reserved for women.
So
That
same
is
for
the
public, it's a person with disability.
Right.
For general category also, you will have a person with disability.
So let's come with your rules, etc. on Tuesday.
There are no rules, Miller. They say there are no rules, and therefore we had to
Then
find.
if there's a resolution of the committee, or what is it?
No, rules, my lords, are there. The rules of the RJS 2010 rules, my lords, for women, it's separate. I mean, it says that category wise, the reservation would be horizontal category wise. But for persons with disabilities, we are adopting the
We'll
rules.
take it up next Tuesday. We'll see.
What it does, it creates a bottleneck.
33, I'm seeking a short accommodation. Learned Solicitor General is appearing, my lord, in 33. The personal 33, and the last date of hearing, my lord, 33. 33, the learned Solicitor General is
necessary, not a proper party.
learned Solicitor General appearing, my lord.
No, no, we have-
My lord, on the last date of hearing, my lord, have directed to since.
First rule of advocacy, when the bench is with you, don't intervene. You might just turn the bench against.
My lord, on Tuesday, my lord, since learned Solicitor General is appearing.
Oh, you participated in the earlier proceedings right up to the Supreme Court, and now in execution you say we should be made party.
But a question of law is ready, but Tuesday, my lord. My lord, tomorrow, my lord, maybe.
My lord,
would
my
not
lord,
take
my
40
lord.
next week.
Which one?
40.
40. 40
My lord, I was told your lordships were not.
40.
Please, my lords. Any time next week, if your lordships.
Cooperative society.
Please, my lords, please.
Oh, that was only, they say to pursue the application for intervention in an application filed with a petition before the division.
No, we only wanted the third direction just to argue on that, because without even permitting them to intervene, an interim order has been passed in their favor.
Dr. Muralidhar, they have acquired title. They have acquired title.
We are not
auction point.
My lords, we are not so much on the intervention, my lords, because that will be decided.
And now, you are the erstwhile owners who want to sort of put a spoke in all.
Not really, my lords, because that's a fight between the society and this woman.
Correct.
My lord,
My lord, my lord, short indulgence, short indulgence, my lord, my lord,
appearing,
short indulgence, item 13, my lord. The CLB to NCLT contempt matter, my lord. Just a short indulgence, my lord. We have withdrawn the matter with the liberty to file execution. My lord, if it may be recorded that now this proceeding will fall under the new act, my lord, because we will be faced with the same
Not clarifying. You argue that over there in your execution.
Lordship, item 33 may be on tomorrow, my lord. Learned Solicitor is appearing, my lord.